Okay. Mr. Reimer, response?
Yes, sir. My client is present. I don't know that I have an objection to Ms. Robinson's position wanting to secure a mediation date. I don't think I've received those dates from her. And I haven't talked with my client about his availability on those dates. But I certainly understand the need to go ahead and get that secured, and I have no objection to that.
Okay. And
Judge, I
Mr.
can
Reimer, Mr. Reimer, do you have any objection to Ms. Kern? And I know you may be coming off the case, so what I may do is go ahead and hear your motion to withdraw next before I actually give a concrete date and a concrete mediator. But from your standpoint, do you have any objection, or are you aware of any objection to Ms. Kern serving as the mediator for final?
I am not. She actually mediated the temporary orders in this case. It ultimately was unsuccessful, and there was a hearing in front of Judge Mullinex, but I do think that that she was a good fit for the party. She's got some factual background just because of her previous experience with the case, and I think she would be a good, if I use her actually in a lot of other of my cases as well, so I have no objection to her.
All right. All right. Well, the motion to compel mediation is going to be granted because it is a local rule. And I'm going to hold off on appointing the mediator and giving a final date because that's going to be determined by Mr. Bain's schedule in the event that I let Mr. Reimer off the case. So, Mr. Reimer, if you want to go ahead and proceed on your motion to withdraw, you may do so.
Yes, Your Honor. My name is Aaron Reimer. I've represented Mr. Bain since the beginning of the case. It has come to a point where Mr. Bain and I are no longer able to communicate effectively. There has been some pause in the case as the parties just sort of were operating under temporary orders. Now that it appears that we need to get going, or the case needs to get going when it comes to resolution, either through settlement negotiations or through trial, I am not able to continue to represent Mr. Bain. I provided Mr. Bain with a copy of my motion to withdraw. As you can see, he is present here for the hearing. And so I would ask respectfully, Your Honor, that the court permit me and my associate Chase Weber, who's also attorney of record, that the court permit us to withdraw as attorneys for Mr. Bain.
Thank you, Mr. Reimer. Ms. Bastine, Ms. Robinson, I'm sorry, any objection to Mr. Reimer withdrawing from the case?
Judge, my only objection is that I won't have an opportunity to work with Mr. Reimer, and I was actually kind of looking forward to that opportunity. But that not being a legal objection, no, Judge, I don't have one.
Very kind. You're very kind. I appreciate that.
Mr. Reimer is a pleasure to work with. Both of y'all are a pleasure to work with, but he's an exceptional lawyer. Mr. Bain, if you would please unmute, and if you can get your video up and running, that would be great for me. I just want to see if you have any objection to Mr. Reimer coming off as your lawyer.
Let's see, is this working?
Yes, sir.
All right, sorry, I'm at
You've
work,
heard
so
Mr.
I'm
Reimer.
still in.
You heard Mr. Reimer tell the court that he doesn't feel like y'all have a healthy working relationship going forward on this case. Do you have any objection to him being removed as your lawyer on the case?
My biggest thing is I do disagree with the communication. The communication has kind of been, for lack of better terms, wishy-washy on their part as well. As things have been sent to me, I've asked, I don't know what any of this is. Obviously, I'm not an attorney. I don't live in a courtroom. I've asked multiple times, hey, what is this? What is this? What is this? Gotten zero response from them. And then the very minute dialogue that went back between me and Mr. Reimer was very hostile on his behalf. And when I said, look, this is going to be very damaging to the case, especially right before, hey, let's go to mediation. I do understand there's things that I'm responsible for and I'm working on with him, as he knows. I'm not against it, but all I've asked him is to give me enough time to find new counsel, because to drop right before the end will be very damaging. I don't know anymore. I don't know all the technical terms and things I should say, not say, but that's kind of where I stand as we sit today.
Thank you, Mr. Bain. The court is going to grant the motion to withdraw. Anytime a client or a lawyer tell me, Judge, we just feel like we're not a good fit anymore, even though we may have been for several months. Normally, unless it's just on the eve of trial, I'm inclined to grant the motion to withdraw and let you go get new counsel. Mr. Bain, I am going to give you a little bit of time to obtain new counsel and for new counsel to get up to speed on the case. But I can tell you that this case is old. And so I don't think that that's healthy for the parties to be under litigation for a long time. And so I have an incentive, because I think it's best for you and for your wife to get this matter finished fairly soon. And so I do want to do two things today. I'm going to appoint a mediator, and I'm going to give you a deadline to mediate. But then I also would like to get a trial date set as well, just so there's something on the court's docket. Let me look and see how old the case is.
I believe it's a 2017 case, Judge.
That's correct, Your Honor. We filed our
Yeah.
petition for divorce in December of 2017, December 4th.
Yeah, so it's a case that needs to get done. And my hope is that y'all can get it resolved with a mediation. Mr. Bain, did you have any objection to Lori Kern serving as the mediator? She previously mediated y'all's case. Do you have any objection to her mediating the final?
No, she was fine when we dealt with her last time, so no, not at all.
All right, Mr. Reimer, the court's granting your motion. Let me see if I've got an order. Can you see me tab 36? Oh, sorry, I'm looking at my queue, not the court queue. Got it. All right, Mr. Reimer, I've signed your order. Thank you very much for appearing today.
Thank you, Your Honor. May I be dismissed?
You may.
Thank you.
Take care.
Thank you.
Okay, Ms. Robinson,
Yes, Judge.
for the deadline of mediation, do you have any opinion as to when you'd like to have that set?
Judge, 30 days, I believe would be good. The dates that we received from Ms. Kern went through May 27th. So that if we could be in mediation, within 30 days. I do understand new counsel coming on. If new counsel ask for some more time, I would definitely not be objectionable. But I do want to give us sort of a timeline to kind of move forward.
Sure. What was her last date that was available? Was it May 27th?
May 27th was the last date that she gave us. So I'm sure she has.
And does that work with your calendar, Ms. Robinson?
Yes, Your Honor, May 27th is a good day for our firm.
And is that an all-day mediation or half day?
I have scheduled it for a half day because they have been operating for so long under temporary orders. We would probably pick a morning and just ask Ms. Kern if we could, pay for additional time if necessary. According to my client, she does believe that we can get this resolved. So I am hopeful that we will be able to resolve it in mediation.
All right, Mr. Bain, I'm not sure if you heard all that, but I'm going to kind of explain it to you as best I can.
Yes, sir.
I'm going to set a date for you to mediate, and that date is going to be May 27th at 9 a.m. with Ms. Kern. It's
Okay.
very important. I understand you're just withdrew. So it's important for you to get on the phone and go in and meet with someone soon so that they can get up to speed prior to that mediation date. If for
Yes, sir.
some reason they need a week or two to get ready, which could be the case, Ms. Robinson, I know her and she's very professional. I'm sure she'll give your counsel another week or two if they need to get up to speed. But we're going to set the mediation for May 27th. And if your new lawyer has an issue with that date, just let them know to contact Ms. Robinson's office.
Yes,
The
sir.
other thing that I want to do is set y'all for final trial. And I'm going to do that far enough out so that lawyers don't have to do more work if the case settles at mediation.
Yes, sir.
So, but I also want to get it that. So let me look at that. Let's say Ms. Robinson, what does the week of either August the 16th or August the 23rd look like for you? You have a
Judge,
day?
the whole month of August doesn't look good for me. If we could go to the first week in September, I really appreciate it.
Sure, I can do that. So
Thank
with the
you.
first week of September would be September the 6th through the 10th. But
Mhm.
September 6th is probably a holiday. So
It's probably
the 7th through the 10th.
any one of those days, Judge.
Let me look at my calendar, the court's calendar. All right, let's do September the 8th. That's that Wednesday.
Okay.
And that will be at 9 a.m. with Judge Hepard's regular docket call. And again, hopefully, Mr. Bain, y'all don't need that trial date, but it just helps to have a deadline for the end of the case if we don't get it resolved.
Yes, sir.
All right,
Understood.
I'm going to interlineate that specific date in your order, Ms. Robinson, for the mediation.
That's fine, Judge. Thank you.
And otherwise, everything's granted, and I'll sign that order now.
Okay.
All right.
Thank you,
Thank
Your
you,
Honor.
Mr. Bain, for appearing this morning, and
Yes,
best
sir.
of luck to
Thank
you.
you.
Thank you, Ms. Robinson.
Thank you.
Thank you.
Hear that buzzing? Sounds like there's some feedback somewhere. I don't know.
I'm just gonna try another phrase. The last one.
I'm on, Judge, just so you know.
Okay. I was just going to talk to the lawyers just for a second.
Okay, I'm trying to get my physical being there for us. But apparently the camera is having a different feeling about the matter.
This is not a cat.
What's that?
So at least he's not a cat.
It is not happy. Okay, hold on. Let me see if I can get to a different way. There we go. Yes, sir.
There we go. So, and we're not on the record yet. I was just, because I'm going to take, Mr. Broussard announced, Mr. Trachtenett docket call that it would be an hour and a half to 2 hours for his hearing. And then I know you had a motion to sell real estate as well, and it sounds like y'all may have an agreement on that from docket call, but I'm not positive. So I just wanted to talk to the lawyers and find out what all's set and what do we have agreements on before we get on the record, and then we can put all that on the record.
Good morning, Your Honor. I have a motion to extend basically the prior temporary orders with regard to the previous order of spousal support. I have an additional motion for expert witness fees. You've given us previously $6,000 for that. We've already got up to almost 14,000 in that, and more coming. With regard to whether or not we were in agreement to sell the home, there's some other issues that would have to be addressed, like moving, storage, realtor issues. This is a substantial home, well furnished. So those are real expenses that would have to be addressed also.
But is it my understanding that there is an agreement to list the property, Mr. Broussard?
We don't have an objection to listing it, Your Honor. We don't know. Yes, Judge, there's an agreement. We list it. I think it's going to be a timing issue. It's going to be a moving issue. It's going to be storage issue. It's going to be a realtor issue, or it could be.
Your Honor, the concept of selling the home and getting it on the market at this valuable time is what we want to do also, but the home will need repairs and brought up to speed for a sellable home versus a home that has patches here and there. It needs to be primed up. It's worth anywhere from $1.5 to $2 million, somewhere in that range. And it needs some substantial sprucing to be done. And it needs to be probably, my client's the person who has the contacts list on that stuff. So there's some detailing that Mr. Broussard and I have to work through.
We are in response to that.
Y'all want to be put in.
I'm sorry. In
Go ahead,
response
Mr.
to
Broussard.
that, I can just say that, the parties agree that the house will be listed. Then me and Mr. Tracton over the next several days can work through that. And if we can't figure out how we're going to do that, we'll just have to address it again. That's the only thing I can say about that, Judge, because I think I don't have any documentation reflecting what needs to be repaired, where those sums are going to come from. And I think that's a little too much for today, Judge.
And I wouldn't disagree because I don't have that list either, Your Honor. My client has it off the top of his head, but that would not be effective as complete list.
Okay. So then what we can do is just get on the record. Well, what about a realtor? Do we agree on a realtor? Or do y'all want to talk about some of the easy, well, I say easy. Y'all want to talk about some of the things that y'all might be able to agree to, and then I can put y'all in a room and y'all can talk for 10 minutes or so, and then, or 15, and then we'll come back and get started on Mr. Broussard's motions, and we can recite at least any agreements that we do have as it relates to when to put the house on the market, who the realtor is going to be, and maybe that, husband has access to the home to, to inspect what needs to be done to spruce up, or the realtor does. I mean, y'all can talk about those issues if I put y'all in a room, or if I leave and let y'all do that before we get started. The other thing is, go ahead.
I was just going to say, I think that would probably be valuable, at least to get the check marks on the stipulated side of it.
And then on the, because, the other thing is this case was filed in August of 2020. So, I'd like to get it set in the next 3 to 4 months for final, if not earlier, because I think it needs to get set for final trial.
Your Honor,
What do we have as far as, go ahead, Mr.
I
Tracton.
need to respond to that. We have properly requested through deposition on written interrogatories information necessary for Beth Hurst to complete a forensic appraisal of the business, which is wholly owned by community. A little bit than about 5 minutes ago, we got a motion to quash on all that, all kinds of objections. My thoughts are at this point that I'm probably going to be bringing in Alan Cease to handle that. Probably going to need, certainly going to need more attorney's fees and things of that nature. So I'm ready to get this case tried too, Your Honor, but we keep running into obstacles to get to the finish line.
I don't know if the court recalls from a prior time that this is a case of diminishing liquid assets. There's nowhere near enough money to do what needs to be done other than just a few $1,000s. It does not have a 1 month's worth of paying bills in an account.
Your Honor, may I respond to that? That would be real easy for me to swallow if they would have voluntarily produced one document from an entity they've owned throughout the marriage that has created this entire $3 million plus estate. That'd be easy pill to swallow, but I get hit every single time with an objection. The appraisals themselves, Your Honor, on the real property increase the value over Mr. Minot's interrogatories by over $600,000. So forgive me if I don't believe we're in that dire straits.
Your Honor, there is
Well,
no,
we'll take that up in this.
it's the liquid assets.
We're going to take
aspect.
those arguments up. Well, we're going to take those arguments up in the hearing, I'm sure. So I want to hear them once. So sorry to interrupt you, Mr. Tracton, but I don't want to fight that battle now when we're going to be doing it on the record here in a second. But I will let the lawyers know that the final trial date is something that's in my head. So, and that was normally when I set temporary spousal support, I set the temporary spousal support anticipating that this is how long I think the case should take. So, and I know the temporary spousal support has run out. So I'm going to listen to that evidence. It may be that, well, I've got to hear if there's resources to pay it and all that. But typically, if I'm going to extend temporary spousal support, then I'm going to want a final trial date so that I know where this case is continuing to move.
And Your
not
Honor,
getting bogged down.
if I can just say, I know this case was filed in August, but it did lay dormant due to the lack of action on either of the parties. So it didn't start getting geared up until we had these temporary hearings, Judge.
Okay. So the temporary hearing, let me look at that real quick.
November, Your
It
Honor.
was in November, Judge.
November 17th.
Yeah.
So really, and we've got and this is the one where isn't there litigation dealing with the community business, or am I thinking of a different case? Wasn't there a
There is, Your Honor.
pretty significant claim on?
Yes, Your Honor, and that's been another reason we have delayed requesting this valuation, because we were promised the business was going to be closed and all types of things. And we believe that's just not an accurate representation.
This business still is in litigation. An injunction was able to be acquired to keep the doors from being locked out by the state while it's being in the next.
And the litigation is with the state, like I forget if it's a sales tax issue or it's something related to the state, right?
It is a tax issue. And it's well
All right,
beyond
I'm
the
gonna-
value of anything.
Again, real
What
simple.
I'm going to do, lawyers, is, all right, I'm going to cut my video and I'm actually going to leave and go get some coffee and maybe look at some orders from yesterday afternoon or yesterday evening. I'm going to give y'all about 15 to 20 minutes to talk about the house issue. As soon as I come back on the bench, I'll start my video and I'll let y'all know that I'm here. So I'm not listening to y'all. I'm not going to create a breakout room since y'all have your clients with you. Y'all can just talk and I will mute and cut my video. And as soon as I come back in, I'll let y'all know. I'm not going to listen to any of y'all's negotiations. All right. Thank you, lawyers. I'll be back at, let's do 10:15. We'll start the.
Thank you, Judge.
What is the name?
Jennifer Shuley.
Hey, Mike, can you hear me?
I hear you, sir.
Okay. We would like to use a realtor named Jennifer Shuley. Is that correct?
Yeah,
I'm trying to Google her right now.
it's CUI.
It's spelled CUILA. She's with Remax and she is very known in the Siena area. She sells estate homes. If you look on her website, you'll get an idea of what kind of homes she's selling, but it's typically $1 million homes. And Mike, her website is Jennifer, JENNIFER Shuley. This is not broken up. CIULLA.com.
Is that, where's the at part at?
Wow, I'm reading it right off her link. There's not. Okay, here's the full thing, Mike. It's Jennifer Shula A. Home. Oh, why does it not have an at? You're right.
I emailed it to him, check his email.
Oh, check your email, Mike.
I emailed it to him at 8:30.
Email it to Nancy or to him?
Oh, at 8:30.
It was emailed to both you and Nancy at 8:30, Mike.
And there is no at, it's just jennifertruly.com.
No at, just jenniferchuli.com.
Ats are only for email addresses. Ats aren't for
Oh,
websites.
yeah, add your email addresses, Mike.
Sorry, you can hear me.
Yeah, it's all right.
Sorry.
No, it's okay. You got about 1 million.
I
All
have it.
right.
Where's the appraisal for the house?
Hey, Scott, what's the status of the house appraisal?
We held off on it because it was being, y'all said you wanted to sell it.
Well, the appraisal would have been a valuable means of knowing what it was worth.
Oh, well, I understand, but I didn't want to spend another $800 on something we were going to sell.
We've already.
I mean, if
We
you,
didn't know we were going, we didn't, please let me do this.
Okay.
well, hey, we'll get an appraisal. No big deal.
Now, the reason is because we didn't know till this morning you were in agreement to selling it. So we've been
Yeah.
looking for an appraisal.
Okay, but it sounds like you still want an appraisal. So what do you want?
What do you want me to do?
I mean, I know what the house is worth. They
Okay,
wanted to
just
have all the
do-
properties appraised.
Do we need an appraisal or not?
We've paid for it.
It's not paid for yet.
No, we're about $9,000 upside down in fees, so it hasn't been paid for yet. Do you want to do the appraisal, Mike?
What do they want to list the house for?
Do you have an estimate or does your client?
I
have-
think we would have to talk with a realtor and, that language, Mike, would defer to the realtor's judgment, right? And we could probably put in there something, Mike, also that the parties would have to accept a sale price. And given the price of this house, maybe within 2 to 2.5% of the ask price. That way, neither one of the parties can, if we get a $15,000 less than the ask price, no one can go, no, I'm not selling it. So we could put some kind of buffer language in there that we follow the realtor's recommendation. Then we put a margin in there of what the parties would have to accept within that range.
I'm going to say I have a problem when we allow a realtor to set a price where they make a fee.
Well, then I think given what the other appraisals have come at, which is I know you're missing some of them, when you total them, they're about $650,000 more
He has mentioned.
than in the interrogatories. So I think we need to go ahead and just to be safe, $800 relative to what this house is going to sell for is probably nothing. So we probably need to go ahead and have that house appraised.
I will email the appraiser again.
So we can email him right now and get him on it.
I think that will be a great deal of assistance to whatever the realtor is going to tell us to.
Very good. We'll email him right back and get him back on it, Mike.
Thank you.
Where's the appraisal for the Hitchcock lot? Where's the
He
appraisal?
said they don't have them all there. How soon can we get this on the market, get this moving along? Because I think that's really important.
Well, I haven't talked to my client about what the necessary repairs would be. So that's going to be one thing, correct? So we got to figure out what that's going to be. We're not trying to delay it, but I think you're probably looking at 60 days before a house can be on the market. That's a house in good shape.
What if we don't need to wait 60 days and we can do it in, between 14 and 30?
Well, the house has to be on the market within 60 days and we got no reason not to do it, right? So, I mean, I don't know, but we've got a second, we got a second problem here, Mike. We haven't had a temporary orders hearing. We don't know what the judge is going to order regarding payment of temporary spousal support. We don't know where my client's going to live. We don't know what she's going to be able to use for rent, moving expenses, things of that nature. I mean, this has just opened up a whole new door. That's why I didn't think we would be ready to resolve it today. Because she's now got to go out and find out, well, what's rent going to cost me? What are the moving expenses? What are the storage expenses? Where am I going to live? So these are all numbers that I have to have for purposes of her spousal support numbers, Mike.
Well, I do hear you, but we still need some cash flow because there's not going to be any community cash flow.
Yeah, we got 10 vehicles we can sell. Out of every asset we have, there's only one that's depreciating. That's all those cars sitting in the garage. Garage won't be there to store them anymore. So
we have a place to store them.
well, but I'm going to ask the court to sell vehicles. We're not going to sell. I'm not going to agree to sell the assets that appreciate or the assets that are earning the estate money. I'm going to ask the court to sell depreciating assets. And then and I'm going to be back in here in 2 weeks now because of what's going on, because what was filed this morning, looking for more fees, more expert fees, and probably bringing in someone just to handle the corporation.
Well, you do realize that when you ask, you can't ask interrogatories to usurp you haven't brought a party in, and you're just using the deposition or written questions as a request for interrogatories when it's a production request.
Well, I'll look at it. If you can't do it, we'll redo it. But we'll keep going whatever route we need to go, Mike. I'll look
Here's the thing. Let me tell you
to make this easier, I'm probably just going to interplead Texley. I'm probably going to serve him. Just bring him in. So I'm just tired of this. Everybody wants the divorce done. This is not going to happen without Texley being appraised, without us looking at Texley documents. So we can do this as long as we want. I don't care. I don't care. I'm trying to save my client money. You know, Mike, I've only billed my client $8,000 in fees to date. That's
I don't know what you billed.
Well, I'm telling you. So we can keep spending money, and my client can keep getting phone calls, getting yelled at for the money that's going to this. We can keep doing it.
Scott, and with all due respect, this is a give and exchange. My clients ask over and over again to be able to sell this house.
We're selling it.
Wait. The last conversation was over a month ago, and today we're getting the discussion of.
He wanted to move back in. She even told him, yes, you can move back in. He
wanted
hasn't
to do the repairs.
one document where he's renting place. He's paid his rent in advance, apparently. So, I mean, no one is acting like everybody says they want this done, and then no one is acting like they want it done. So it is what it is. We'll burn Rome if we have to.
Okay. The aspect of the monies we've been asking for, bring the corporation in, then you got your corporation to answer questions. It's not, the corporation can't be represented by me nor your client. They're shareholders. They can't represent themselves in this divorce, and we can't represent.
Mike, we agree to produce stuff like this all the time to save people money and fees. But we're going to do it the way you guys want to do it, and we're going to spend $100,000 doing it. That this estate doesn't need to burn, but that's fine. I don't care. I don't care.
Up $100,000, but I guess you have a number from that. I do know
because we're going to bring in more lawyers now, and we're gonna, you're gonna fine. It's a lot easier. It's a lot easier to pull a chain than it is to push it. But we'll keep doing it that way, Mike. I don't care, but I don't want my client receiving texts about her wasting money on this stuff.
The wasting is that there's plenty of money. I would tell you that your client's in control of assets that she can access.
We're going to sell the cars.
No, I'm talking about the riches of jewelry she has.
Yeah, those are separate property gifts. We're not selling. Those are assets that appraise.
Property. They're not separate property.
But that's a matter for final. There's no issue about the cars.
The cars themselves, you refer to them as depreciating assets, or why do the part of the reason why they're depreciating is my client's unable to gain access to the house.
Oh, come on, Mike. Come on, Mike.
Harassment.
You drive a car off a lot, it depreciates. Yeah,
those kind of cars.
It's not a classic saving car. It's not. The only one that's worth the damn price is that 240Z, which I do like. So I won't ask that the 240Z be sold. But we're gonna sell cars, Mike.
We're going to sell. We have lots of things to sell.
We're not selling real estate. We'll sell the house, but we're not going to sell
real estate.
We're not going to sell the other real estate that's appreciating in value. We'll sell the house. That gives them 1.2 million, 1.5. We can put it in the bank and we can chip away at that when we have to start doing it. I don't care. Put it in ILTA.
You're right about something, except the sale of the house happens when it occurs. And that's not going to happen until the buyer buys it, until it's put on the market.
Oh,
and until
sure.
it's fixed
But
up
I can
to
drive
the-
down to Texas Direct today and get every one of those cars sold.
But that's
Everyone-
undervalued. That's
What's that?
undervalued. That is undervaluing.
Now, the value of the car is what a dealer will pay you. We're not going to do private sales on this.
Why are you discounting the cars?
You guys also got a $10,000 tax return. We haven't seen it, have we?
A $10,000 what?
Has not come in.
Tax refund.
There's no money hasn't hit.
Okay. Well, it doesn't matter. Y'all, I'm following your lead.
And we're having to follow the one that's being limited to us.
Really, Mike, what time have you ever served, say, handled a case when you didn't value a corporation and no one would give you any records to it? Tell me when you've ever done that in your career.
That is
Never.
the only way I've done it in my career.
Okay.
I've done it only as a separate entity.
Okay, Mike. You know what? Give me all the stuff I want from it, and maybe we won't have to have a value. But you're not giving me anything, so we're going to have value.
All you need is to bring the corporation in, and then the
I'll bring
corporate
them in.
lawyers help it out.
I'll bring them in, and the estate is going to dwindle. And when your client calls mine to bitch about it, I want him to remember this conversation we're having, because that's what's going to happen. He can roll his eyes at me all he wants. That's what's going to happen, and he's going to see it go. And it
Your
doesn't have
client
to
is
happen.
well aware of the problems of that business.
Mike, you're well aware that the minute this litigation's over, the state of Texas is not in the business of closing entities down. They're in the business of collecting money. So what they do is they work out agreements. They work out easy payment plans. That business is thriving. You ever
That
dream
business
about
is-
it at night?
That business is anything but thriving, just to,
Okay, well
bring
then
that
give
up
us
to
the
you.
information on it to prove what you're saying.
and all you have to do is go in and let the corporate lawyers do it.
I'm gonna do that. We're
Okay,
gonna
that's
spend
what
more
I'm
money
saying.
doing that. Otherwise, y'all just give it to us and we can say, golly gee shucks, they're not lying. They're telling the truth. It's not worth anything. Don't go waste $25,000 appraising it, but y'all don't want to do that. This is not, let's make a deal. You can have, this pin, or you can have what's behind that corner. We don't play it like that. But that's okay, Mike. We'll bring the corporation in. We'll bring them in.
Been talking
Bring
about
them
it for
in.
many months, and here it is finally.
It doesn't matter. Well, no, sir. You told me the corporation was going bankrupt and there were going to be doors on it. And your client testified that I'm looking for a new career. So I said in open court, Your Honor, in light of the testimony today, I'm going to hold off on the appraisal of that business to see if what they're saying is actually true.
And every bit of it was true. And the
Only
lawyers for
you-
the corporation,
The
Scott,
only-
if you want to let me answer you, I will. Otherwise, I'm
It
just
doesn't
going to have to
matter.
listen.
It doesn't really matter, Mike. You told me your answer. Bring the corporation in. So there's no point in arguing. I'm just making my point that when this money gets spent, don't look at us. Don't look at us. So we'll bring the corporation in. Not an issue. Matter of fact, I'll have it filed today.
Excellent.
Go ahead and start drafting that. That's what we talk. Draft amended petition, add a respondent and text. Okay, so Mike, do you want to go and quiet on your own and do a little research on a realtor, or do you not want to do that this time? Or
Find a
turn
different-
off your mic?
Are you okay with this,
Yeah.
realtor? We're okay with this, realtor. Are we able to
Okay.
get any benefit of fees or any like a reduction of fee?
You know what? Sean's a businessman. If he can get her to reduce to 5% or whatever, I've always had trouble getting realtors to come off theirs, but they kind of lockstep together. But that's also something the parties can negotiate. If they get a low ball offer on the house, then maybe they can say, well, if you reduce your fee 1% or whatever. But especially in these bigger homes, I haven't found realtors that.
What the asking price of the house would be.
You won't know yet. It's too soon. We need the
Well, I
appraisal.
already
for that
have the
answer.
appraisal, it's at 1.25.
What
Wait,
price are you talking about?
wait. CAD appraisal is at 1.25.
No,
It's probably $200,000-$300,000 more than that. It's probably
None of us use
1.55.
those. None of us use those.
Okay.
Not on a house like yours. But the aspect of, we have the name a realtor. Part of the logistics we got to work with is, my client is the one that can get that house fixed up and everything. Your client needs to put stuff in storage and work out where she might be residing. Just like my client, a reasonable priced home is exactly what she needs to locate in the interim. Once everything gets sold, she can find herself a place to live, that whatever her share of the estate is, but we only have limited resources at this moment. And whatever that, even the vehicles were to sell for, that's just a small Band-Aid of a terribly bleeding wound.
But y'all are bleeding it.
We're
Y'all
not.
are bleeding it. It's
I'm
your
reading
election.
FIS that says damn near $10,000 a month for expenses.
Your election to bleed the estate.
That's not his.
It is your election.
He's trying to sell the house.
If you
That's a
want to
big.
settle this case, if you wanted to settle this case, we'd be moving forward with getting an evaluation of the business. So y'all can tell me, see, Scott, screw you. It's not worth anything. But y'all aren't doing that. So you're electing to bleed this estate. The depreciating assets are the cars. We've got over $200,000 worth of vehicles. We got no need
You're
for
referring
them.
to that large Mercedes vehicle?
No. They're going to keep their primaries. They both got nice cars. There's no reason they don't need to sell their cars. We're going to start selling the ones just sit in the garage. And we'll sell as many as we have to. I'm just going to ask today for one of them to be sold to cover the expert fees. That's
And
it.
you have an idea which one that is?
I think that 2020 is one of the Jeeps. I know one of the Jeeps has already been sold because it was
Because it's a son's vehicle?
traded in or something.
Yeah, the son used it and then bought himself a truck that he's paying for.
Right. So I'm thinking the 2020 Wrangler XD probably be a good one to put up for sale.
What one was that?
I'm not selling anything.
The 2020 Wrangler XD, because I believe the 219 Wrangler was traded in. So we could probably sell that one.
Well, where is that one you're referring to?
In your interrogatories, page 8 of 20, I believe it's the first one y'all have listed, Mike. Hold on one second.
I mean, where is it physically? Is
Second
what
one
I'm
you listed. Bum, 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 bum.
Where
What?
are your
Oh, they're sitting right there.
This one too,
What's the other one?
a white BMW X4.
BMW X4. Okay.
This one.
I'm not going to do what they say. No,
Don't say anything right now.
no, I just-
What's that?
Said that one is also one.
Okay.
I don't want to talk on the record, right?
Yeah, that's, is that the new case? Okay. Need to put this attorney of record address in there.
Alright.
Yeah. Where's that? Mm-mm.
Yeah.
Well, time has passed. What,
I
Chandra?
don't know what you did with it.
What are you doing there? What?
I'm going through Matt Hare's documents that are due today for disclosures. He was 3 payments away from paying off his vehicle. He totaled it 3 weeks ago.
Oh, poor guy.
He said he went ahead and paid it off, so it was a clear title, but now he needs to go buy a new car because his spare car is not compatible with
Mhm.
his professional commitments.
Yeah, I would agree with that.
Oh,
I would agree with that.
so you're gonna have to address that.
Well, it's a reasonable and necessary expense. Just tell them don't buy a light car. Tell them don't go out and buy something.
Three mechanics on the other side, you sure you don't wanna run this by them?
What's that?
I think mechanics on the other side.
Well, what's he getting for the payoff?
Matt. Hope you not do this in there.
Okay, would you do me a favor? Would you go mute Pam? Is Pam muted? Mute yourself, Pam.
What are you looking for, Michael?
I'm just breezing through the file, see if there's anything. Hold on a second, I'm gonna mute ourselves out of this thing.
I've made a lot of money on real estate
On this,
too.
no, open mic. Allow me to do my thing.
Go get on the screen, please.
Court's on the record in cause number 20, DCV 275451. Counsel, if you would, please each identify yourselves and the party that you represent, beginning with petitioner's counsel.
Your Honor, I'm Scott Broussard. I represent Pam Minot.
I'm Michael Tracton, and I represent Ashvin,
Sean Minot.
but he goes by Sean.
All right, anyone that's going to provide testimony today, if you would, please raise your right hand to be sworn.
Yeah.
Each of you solemnly swear or affirm the testimony you're going to give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Judge, are you able to
Thank you.
hear
You
our
may
end
put your
okay?
hands down. I can hear you just fine, Mr. Tracton.
Thank you.
Mr. Broussard, Mr. Tracton, are there any stipulations as far as exhibits or any stipulations as far as agreements that we need to recite into the record before we get started?
Well, Judge, while Mr. Tracton and I worked towards some agreeable language on the home, I don't think we have anything that we can put in the record. We can't necessarily agree to timeframes. I think they've agreed to a realtor. I believe they've agreed to go ahead and get the property appraised, complete the appraisal for purposes of setting the sale price. Outside of that, I'm not sure what we could agree to on the record as a request for an immediate sale is going to cause me to request more for temporary spousal support than I anticipated because of the cost of moving and getting a new rental place, Judge.
And Your Honor,
Okay.
I don't know, I do know that from this party's point of view that those costs can be partially offset by each of their employments and the contributions from employment, but they can reduce their expenses substantially on a monthly basis by making the house go away faster. It'll be a far greater thing to do. And that's where we have a difficulty right now is the fastest way to make it happen, not just trudge around, let's get the storage, let's get the repairs done, realtor working.
Your Honor, there's
Mr. Tracton, you had a motion.
on the home.
I'm sorry.
I said there's no mortgage on the home, so we're going to be going from a zero mortgage to about a $3,000 a month rent. But that's my concern, Judge.
Except that the housing expenses far exceed that.
Mm.
And if it goes away,
Mr. Tracton, you have a motion. You have a motion for additional temporary orders where you're trying to sell the home today. Is that something that we're going to go forward on that motion today, or are y'all going to try to work out the details and reschedule that in the event you need it? Or are you wanting your hearing on that?
Your Honor, the actual, I think the concept has been met. What we could use though is a backup day if we can't get all the details done and we have to come back here, if we can get one shortly, because this isn't going to take very much time. If it could be done in a week, we'd love to have a date. You know, it's probably going to be a no more than a half hour conversation.
Okay.
In the court.
All right, then the court's going to accept, I guess, the agreement that the parties have agreed to list the property and they've agreed on a certain realtor. Who is the realtor that y'all are using?
Your Honor, I'm going to tell you her name, then I'm going to spell it. It's Jennifer Shulia. The first name is Jennifer, is spelled Jennifre. Go shut her. Last name is Ciulla. She's with Remax Properties. Her phone number is 281 819-0212.
All right, thank you. All right, we're going to go ahead and get into today's hearing. Are there any stipulations as far as exhibits?
Your Honor, I probably have no objection to whatever Mr. Tracton is offering as exhibits. Let me.
And I didn't see anything that bothered me, Your Honor. So from what I saw on there, I don't have a problem with what I see on there, Your Honor. As far as the exhibit, not the questioning on it.
I understand. All right, we'll just, it sounds like it'll go pretty quickly then when you offer them. I won't pre-admit him since,
Yeah, Your Honor, I will stipulate
Yeah,
it. And I think for ease, maybe if we just offered him off right now, Mike offers all his, I'll offer all mine. It'd probably move a lot quicker.
I think that'd be great if y'all want to do that. So I show, just to make sure I've got them all. Mr. Tracton, I show you have exhibits 1 through, looks like 10. Is that correct?
Accurate, Your Honor.
And Mr. Broussard, you have no objections to Mr. Tracton's exhibits 1 through 10. Is that correct?
None, Your Honor.
All right, those exhibits 1 through 10 are admitted. And then Mr. Broussard. Looks like you have exhibits 1 through 5. Mr. Tracton, do you have any objection to petitioners 1 through 5?
I have a 1 through 4. What would be the 5th?
It says Wells Fargo bank statement.
Was that supplemented, Scott?
Yes, Mike.
Okay, I saw something come by, but I was in a mediation, so I didn't see what it was.
And Mike, I think they're old statements. I think you've had them before.
I'm not going to have a problem with the statements being admitted.
All right, the petitioners 1 through 5 are admitted. Mr. Broussard, if you'd like to give a brief opening on your motion, you may do so.
Thank you, Your Honor. We're here for a motion to extend, or rather, for additional temporary orders with regard to spousal support. The requirement for needs of Ms. Manu will probably be a little bit higher than we originally thought in light of the developments of the request to sell the home or the agreement to sell the home. We have, if you will remember, Your Honor, when we were here in November, we were talking about getting appraisals done and things of that nature for this estate, which is a substantial estate. Mr. Minot testified extensively as to what dire straits the Texley Glamour Girls company was in, that it was going to be shut down, that he was going to be looking for another career. In light of his testimony, I stated on the record, Your Honor, I said, Judge, I'm not going to ask for fees for this entity or to get a forensic examination of this entity done. The court awarded at that time $12,500 in attorney's fees and $6,000 to go to expert fees. Since then, we believe that the company is doing quite well. We have not received any documents voluntarily through the company, and we continue to have issues with regard to that. So we have retained Beth Hurst. She's extremely familiar with these types of nightclubs. She's done plenty of examinations on that. Her initial retainer is, if you know, Beth puts a retainer in there and then starts billing and keeps the retainer towards the end. Her initial retainer was $17,000 or $7,500. And with the real estate appraisals, Your Honor, we're already up to almost $14,000 in expert fees. That having been said, we're requesting another $17,000 in expert fees. We're going to request that Ms. Minot receive some temporary spousal support. The evidence will show she has done everything she can to look for a job. You will hear evidence also that she's been hospitalized with COVID. She had substantial damage to the house that she had to take care of, Your Honor. We believe that if I anticipate that Mr. Minot is going to tell us that he's got no money and the estate is broke, and if that is the case and the court is so inclined to believe that, we're going to request liquidation through the assets that depreciate the most in this estate. That's going to be the 10 vehicles that they have. They're easy to sell. We can send them to CarMax today and get offers on those. And we have 2 vehicles in mind. Again, that's if Mr. Minot's testimony is there's no other money in the estate. We will object to selling any real estate other than the marital home, as those are the most appreciating values. And we would object to any request to sell jewelry or anything of that nature. 1, we believe most of it's separate property, and 2, that's another appreciating asset. So with that, I have nothing further, Your Honor.
Mr. Tractor, would you like to give your opening at this time?
Yes, Your Honor. In regards to the amount of expenses and fees that have been incurred for the valuations, I want to clarify that Ms. Hurst is $7,500 of that approximate $14,000 referred to. It is not the property appraisals for which they came in under $7,500, according to the documents I have. The additional amount of money was due to making an early payment. And what I understand, Ms. Hurst has been paid $7,500 as a retainer without us having any more than just that stipulation. That's what she needed. In regards to the additional fees, Your Honor, that if the community estate had some additional fees, I guess Scott would not be the only attorney that'd be being paid. The reference to what the corporation and valuing the corporation, there's been some, the documentation that identifies the state's lien on that property is been sent, it's been out, it's out there. That we don't think that that's a good expenditure to sell, to go into and try to value a business that we have a overhanging document that says there's $1.4 million owed to the state, and the state is fighting like a dog. When Mr. Broussard indicated that businesses would be going out of business, or the state's not in the business of putting people out of business, that is not an accurate statement, and would be testified to that 4 to 5 of the local area clubs have gone out of business because of the tax issue. Mr. Minui fought it, and he's still fighting it. He's at the next appellate level, and he's got an injunction to help him. That's the only thing that's keeping that place running. And he'll testify that not as a corporate officer, but as the person who received it. There was a PPP loan, and that's been drained. That's how these people have been able to receive a $5,000 a month salary. We will discuss and talk about Ms. Minui's efforts to get employed, because the court did make that suggestion very strongly last time we were in court. This court has recognized the fact that this divorce is just an ongoing, nonstop expense and time, and that we can cut that a lot if both parties are contributing to the expenses. They have the court may remember there's 2 children that are in college, and both those children's college goes on, and their lifestyles have remarkably changed. Mr. Minui cut his way back. He was living in that $1.5 million, $2 million house at that time too. Not even the children are there anymore. There'll be testimony to that effect, Your Honor. As far as those cars go and selling cars, those cars are collectibles. You can call them whatever you want, but Mr. Minui has spent a lot of time and effort to make a collection, and that collection is important to him, and he wants to preserve it for the discussions that we take place at the end of this case. There are real estate properties that every month there's a tax accumulated for property. They're undeveloped land, they're lower in their cost as to an appreciating asset. That's great. I mean, you know, that doesn't mean a negative thing, but there may be a way to turn some of that property. The cars, as far as Mr. Minui is concerned, that's not on the table. Those are very important matters, just like a Mickey Mantle baseball card. But the land is just an investment. The house, overpriced expense. The house is a terrible expense. The fact that Miss Minui's health, and she wants to have the best of all worlds. She lives in a house by herself. It's a huge house, a huge expense. It'd be the first thing we can make go away. Mr. Minui is familiar with what needs to be repaired and who to repair it. We will deal with that when we talk about the realtor aspect of it and how fast everything can be turned around, because that's what's important here. And we are of the opinion that my client's of the opinion, because he knows the facts on it, that jewelry is not the separate property that's being alleged. And as such, they weren't bought as gifts. They were bought as walking along. And there'll be testimony of that effect, that the jewelry is an asset that has a value that may or may not have the same meanings to Miss Minui, but when you talk about $250,000 plus, she has control over that, sole control over that, and she's asking for money, and she's not willing to get a job. Those make it important. You can't continue to live a lifestyle on negative income. We are asking the court to deny the request for additional monies to be paid to Ms. Minui. I think my client would be workable with her and trying to figure out a way to get her in a rental home so that she can get started on that part right away, moving things into it, moving things into storage, and get the house on the market. Thank you, Your Honor.
Thank you, Mr. Taylor. Mr. Broussard, you may call your first witness.
I'd like to call Mr. Ashvin Minui, please.
Yes.
You may proceed.
Thank you. Mr. Minui, can you tell us how you're employed?
I'm general manager of the club,
Of what club, sir?
Glamour Girls.
Okay. Is there, are the general managers, is there anyone that is in a position above you?
No.
Are you the sole owner of Texley, I don't know, is it LLC?
Objection, Your Honor, as there is no Texley LLC.
Okay, let me figure out what it is. Texley what? Texley Inc. Are you the sole owner of Texley Inc.?
Your Honor, it's a community asset. I don't know how to say he'd be the sole owner, so I'm going to object as the characterization of sole owner.
Overruled. He may answer if he knows.
I'm the owner of the Texley, yes.
The sole owner,
I'm stockholder.
sole stockholder.
I am.
Okay, so you make all decisions regarding the operations of Glamour Girls, is that correct?
That is correct.
Okay, you make decisions regarding salaries, correct?
That's correct.
All right, so you dictate what you get paid or whether you get distributions or whether you leave money in the company, is that accurate?
Your Honor, I'm going to object if these are questions of the business side of Mr. Minui, or if this is a request on a personal side, since the business isn't here, and these are questions that a business lawyer might or might not be involved in.
Your Honor, he is personally, yes, thank you. Go ahead. Go ahead, sir.
What is the question?
Sure. You determine whether you're paid, whether you're not paid, whether retained earnings stay. Is that accurate?
To a degree.
Well, who else would make the decision if it's not you?
Well, I mean, if there's not enough funds in the business, then everybody's going to have to hold off till the funds come in.
So the answer is you are the only person that makes that decision, accurate?
For my pay, yes.
Okay. But no one else gets paid unless you say so.
That is correct.
All right. Now, I've been on your website, and I know that y'all advertise that you have over 250 dancing girls there. Do the dancers pay a fee when they come in, a shift fee to be able to work there?
Yeah, you've looked at the wrong website.
Okay.
That's not what our website says.
All right. I'm gonna re-ask my question, Your Honor.
Yeah, let's do that.
Thank you, Mr. Minot. Mr. Minot, do you have dancing entertainers that work at your establishment?
I do. And
do you have champagne rooms at your establishment?
Not anymore. The city has told us to go ahead and lock them up. Well, they're not locked up, but we're not selling
Objection
them.
non-responsive, Your Honor.
Okay. So the entertaining girls that work there, do they pay a fee when their shift begins to work there?
They pay a fee. That fee gets split.
Objection non-responsive, Your Honor. They pay after they pay a fee.
Saying after the-
But they don't pay a fee to me.
I'll explain.
Oh, well, I'm gonna
No,
explain it.
no,
Go ahead.
No,
Take
all right,
control.
You pay a fee
Hold
to
on, no, Mr.
hold on.
Hold on, just 1 second. We're getting a little out of control here. Mr. Manu, you're being called as an adverse witness. I want to explain to you what that means. Typically, the lawyer for the other side can ask you leading questions, which may call for a yes or no response or a very short response to just answer the question that's asked. And that may be frustrating because you want to explain or elaborate your answers. Now is not the time to do that.
Okay.
Mr. Tracton is making notes, and if he thinks that you're being led down a way that misleads the court, he's going to give you an opportunity to explain your answers when he gets a chance to question you. So right now, I just need you to listen carefully to Mr. Broussard's questions and only answer the question that he asked. Okay,
Yeah.
Mr. Broussard, you may continue.
Thank you, Aaron. Mr. Minot, I was asking you about the dancers only. I'm talking about the dancers only now. When they come to your establishment to start their shift, you testified, yes, they do pay a fee, correct?
Yes,
And how much is that fee?
$20.
And that fee is paid in cash, isn't it?
Yes,
Okay. And your wait staff, your cocktail waitresses or men, I don't know if you have both, when they come to work there, do they pay a fee?
no,
Okay. They pay a fee at the end of the night?
no,
They don't pay a tip out at the end of the night?
no.
All right. So, sir, you have been, how long have you been operating that business for, sir?
You got it down.
20 years.
Okay. And sir, I want you to refer to your R2, your exhibit R2, please. I know he says they'll operate. Do you have it, sir?
Not yet.
What is that?
That's R2 right there.
Okay.
Let me ask you, in just in general, do you believe that for the year 2020, when obviously we entered a pandemic, do you believe that caused a dip in your business?
Absolutely.
Okay, so if you look at your tax return and you go to the second page of it, that we've got a table there called Federal Income Tax Summary, page 1. Do you see that?
Yeah.
Okay, so on page 1, if we look at our 219 tax return, you declared wages and salary of $160,000. Is that accurate?
Yes.
And adjusted income of $180,000. Is that accurate?
Yes.
Okay. Now, I don't have your other, your last 5 years of tax returns. And just if you don't know the answer to this, you don't have to answer it. But would you agree that for your 2015 through 2019 tax returns, your earnings were substantially the same?
I don't remember. As of right now, I don't remember. The tax returns are still at the house.
Okay, well, let me ask you this. Have you increased your salary over those years?
Depending on the business. If the business was better, yeah, it was increased. If it wasn't, it wasn't.
Okay, and those tax returns have been requested from you, but you've not produced them. Is that accurate?
Objection, Your Honor, as to whether or not he's produced them or not. We don't have that. That's not before the court, and we don't have it to be viewing at this time. But I'm going to tell him he can't answer the question because it could possibly have a Fifth Amendment consequence.
Are you invoking?
Hold on. Fifth Amendment. Hold on. Fifth Amendment. There's a Fifth Amendment issue on a motion to compel. I'm a little bit confused by that.
Yes, Your Honor. This is a question that may or may not be a part of a motion to compel that could cause him to have a consequence that could result in him having a criminal act or action, I believe, from your court.
All right, response, Mr. Broussard.
I want to know what line of questioning he is asserting a Fifth Amendment privilege to. so I can respond. I don't know, is he saying that he is asserting his Fifth Amendment privilege to questions about tax returns? Because he's already answered those. He's already started answering them. So I think that's waived.
Those prior tax years that was told he did not produce is not testifying because he can't remember the answers, Your Honor. And as far as the
I heard
testimony,
that.
I don't know what the answer is to be able to say he might or might not have a problem criminally with those. So I cannot allow, I have to offer him the opportunity to protect himself when it's a federal tax return.
Well, we'll take him then issue by issue. If he's going to assert his Fifth Amendment privilege, then we'll deal with that during the questions. If you can, please rephrase your question, Mr. Broussard, and let's see if we have a Fifth Amendment.
Mr. Manu, I want to ask you some questions about your 2018 tax return or your knowledge of it. And I think that's a fair enough. Specifically, what you paid yourself in wages.
I don't remember.
Okay.
Honest
So-
to God, I don't remember.
Objection non-responsive after I don't remember, Your Honor.
Okay. Did you take distributions over and above your salary from the, can we call it Glamour Girls? That's easier for me to say and understand that we're talking about the same entity.
Mhm.
Okay. Because you're DBA Glamour Girls. Did you take distributions in 2018 over and above your salary from Glamour Girls?
No,
Okay. In 2017, did you pay yourself a W-2 salary from Glamour Girls?
yes,
Okay. Did you take distributions over and above your W-2 income from Glamour Girls?
I don't remember.
How about for 2016? I'll ask you the same question.
I
Did you?
don't remember. Honest to God, don't remember.
Okay. For purposes of the record, let me ask the question though. Okay. For 2016, did you pay yourself a W-2 salary from Glamour Girls?
Yes,
For 2016, did you take distributions above and beyond your salary from Glamour Girls?
I don't remember.
Okay. So, sir, how many hours a week would you say you work at Glamour Girls?
About 30 to 45 hours, depending.
Okay. Do you remember when you were testifying in November in this case?
I remember some stuff.
Okay. Do you remember testifying that you were ready to close it down and get out of the business?
I do remember that's per state,
Okay.
but Mr.
Yeah, objection non-responsive.
Mhm.
You do remember that testimony?
And after I do,
You remember that testimony, sir?
I do,
Okay. So have you closed it down?
not yet,
Okay. Are you working somewhere else?
not yet.
And you have active pleadings. The Glamour Girls has active pleadings against the state of Texas, doesn't it?
Yes, I would like,
Objection non-responsive, yes.
sustained after, yes.
Mr. Manu, have you voluntarily produced any bank statements from Glamour Girls?
no,
Mr. Manu, have you voluntarily produced any tax returns from Glamour Girl?
no,
Mr. Manu, have you voluntarily produced any income statements from Glamour Girl?
no,
Mr. Manu, have you voluntarily produced any balance sheets from Glamour Girl?
we don't have balance sheets.
Okay, so the answer is no. All right. So the only thing you've produced, fair to say, voluntarily involving Glamour Girls was an appellate decision, wasn't it? Correct?
No,
You produced more than the appellate decision?
I have to my
Okay.
business attorneys.
Okay, objection non-responsive.
My business attorneys.
Okay, objection non-responsive.
Hold on. The question was, have you produced voluntarily anything other than an appellate decision? And I didn't hear the answer to that, Mr. Manu.
No,
Okay. Now, Mr. Manu, your position is that Glamour Girls is a zero or upside down asset. Is that accurate?
yes,
Are you objecting to having your wife's request to have, or her intent and actions to have Glamour Girls forensic examination done of that business?
I cannot afford the fee for it. And if that were to come up,
Objection,
I would lock the
non-responsive.
doors tomorrow.
Objection, non-responsive.
Sustained.
I want to ask you, thank you, Your Honor. Ask this question again, Mr. Minot. Are you objecting to having Glamour Girls having a forensic examination valuation done of Glamour Girls?
Yes,
Okay. In fact, you have instructed your attorneys from Glamour Girls to fight any attempt for us to get those records, haven't you?
Objection, Your Honor, as to any communication taking place between he and his attorneys.
Sustained.
To your knowledge, are your attorneys objecting to producing documents to us from Glamour Girls?
I'm going to object again, Your Honor, as to whatever it's being asked about, what's to his knowledge, would be communication with his attorney.
Your Honor, I don't believe that's
Overruled.
communicating. Thank you.
Overruled. He's asking, the objection's overruled. You may answer that if you know.
yes.
Okay, so they are objecting to it. All right. So you think that your wife should be working. To your knowledge, what has she done to not prevent herself from working?
I don't know that.
You don't know that. You don't know if she's on websites, do you?
I don't know that. I'm not in communication with her.
Okay. So to your knowledge, you have no knowledge of her not making attempts to work. Is that accurate?
Ask and answer, Your Honor.
Sustained.
Okay.
That's done.
All right. So now you understand that your wife is requesting fees from the community estate, wherever they may come from, for temporary spousal support and expert witness fees, correct?
Yes,
And you're objecting to her, to either of those, aren't you?
I am.
Okay. Where do you live, sir?
I live Katy area.
Well, the judge actually told you to give us an address the last time we were here, and you still haven't done that, have you?
Yes, I have.
Okay, well, can you state the address? Well, then you instructed your lawyer not to give it to me. So can you tell us what address you're living at?
I'm not going to say that on records. He's got the records and he's already given it to you. There's a reason.
Okay, well
for
then
that.
if he's given it to me, I have permission to publish it here in court then, correct?
Yeah,
Okay, Chandra, look up the address real quick. So sir, you renting over there?
I am.
Okay, how do you pay your monthly rent?
I paid up front
Okay, how much did you pay up front?
$23.50 a month.
Okay, $23.50 times 12? Is that right, sir?
Yep.
Who'd you pay it to?
Belongs to a friend of mine. I paid him.
Right, because the address is not an apartment complex, is it?
No, it's not.
Okay, what's your friend's name?
No, I'm not going to tell you.
Okay, well, I'll tell you his friend's name for us. Do you have, did you write him a check for that?
I gave him a cashier check for it.
Gave him a cashier's check. So it'd be in the total amount for the year's rent?
Yes.
Okay, and that cashier's check would have been given to,
No, that's the address.
the address is 2104 Ironwood Glen Drive, is that correct?
Okay.
Arrowwood Glen Drive, correct?
Yeah. Well.
Okay,
Okay.
and that's in Houston?
Mm-hmm.
And when you moved in there, when did you move in there, sir?
Believe it was end of June.
Okay, so you moved in June, and you're telling this court that in June you gave him a check that whatever $23.50 times 12 is, or you gave him a cashier's check for the entirety of your rent. Is that accurate?
Yes.
Okay. So your rent is $23.50 a month, and that's for one bedroom in a house. Is that accurate?
No.
Okay, what's it for? What do you get for that rent?
3 bedrooms.
Oh, you're renting the whole house,
Yes.
and that's the rental rate in that area of Houston?
That's what I paid.
Okay. Do you feel like he cut you a deal on that?
I don't know that.
Okay. Sir, I want to show you do you, I think from your lawyer's opening statement that there may have been some allegations that Ms. Minot is kind of living beyond her means and wasting money. Is that accurate? Do you believe that?
No,
No, you don't believe that. You do believe she's living within her means.
I don't know that, but I don't think she's wasting money.
Okay, so if her testimony will be, I'm going to need X dollars to live if I have to move out of this home while this divorce is pending, you're not saying that's not a reasonable request. We might disagree about what the money is, but it's not a reasonable request. It's not an unreasonable request, is it?
It's not.
Okay, and the man you're renting from, I'm going to try to spell his name so I don't massacre it. Is his first name Zeidan?
It is.
Is his last name Wajdi?
Yes.
And does anyone else live there with you?
No.
Now, Mr. Manu, I'm looking at your exhibits and I see that R6 is a banking statement from Bank of America.
Mm-hmm.
Okay. Where else do you personally bank?
A bank at Wells Fargo.
Okay. Well, then let me look at what R6 is. Maybe that's one of my exhibits, but it was marked R6. So let me see what it says here. Well, I guess I have to apologize. It looks like your exhibit list might be a little, or I stated the wrong thing. So I apologize for that. Bank of America, the R6 is a Bank of American, it's an American Express credit card, but I've got to draft as Bank of America. But no, it is a Bank of America. I apologize. So this is where, can you tell me what this is? This is your personal bank account?
That's my credit card. That's my Visa card.
That's your Visa credit card? Okay. And so if we're looking at R6, you're showing that you have a total line of credit of almost $30,000 on that credit card. Is that accurate?
It is.
Okay. And the balance that is showing as of the date of this statement, sir, well, actually, this is an old statement. This is December 2020. What is the balance on that card today?
The balance was $1,300. I paid it
Objection, now response.
2 weeks ago.
Okay. So is it a zero balance?
Wait. This card,
Yeah.
99%. Wait, I'm talking. 99%. My son uses that. That's his emergency credit card.
Okay. Are you done talking? May I speak, sir?
I am. Yes, you can.
Okay. So back to my question about this credit card, this emergency credit card that your son uses. Does it have a line of credit of $30,000 on it?
It's my line of credit. It's an additional card I got for him.
Okay. So the answer is yes.
Got 90% of the charges are from College Station.
Okay. The answer is yes. It has a $30,000.
Non-responsive.
Sustained.
Okay. I just want to be clear. There's a $30,000 credit line there, correct?
Okay.
That's yes.
Yes.
Okay. And that card is effectively at a zero balance unless your son has charged something between the time you paid it off and today. Is that fair?
That is correct. That's correct.
Okay. I want to show you because I'm curious as to why you guys offered Miss Manu's credit card, and that's going to be R5. Could you look at R5, please?
Yes. All right.
You there, sir? Okay, now this is an exhibit that you guys offered for purposes of today's testimony. Is that accurate?
Yes.
Yes.
Okay, and also, we'll get in it later, but I think you've got it listed on your financial information sheet. This is a February 8th, 2021 statement. Is that accurate?
Yes.
And the balance at that time was $8,435.
Correct.
Okay. Today, has that balance been paid off, or are you exercising the pay over time option?
No, it's paid off. I'm just trying to figure out why it's so high. Something must have been on it.
Okay. Well, I'm kind of
Oh,
with
I
you.
got it. I got it. It's the tuition. It's the college tuition.
Objection non-responsive.
Okay, I understand that. It's the college tuition, but you're certainly not suggesting that Ms. Minot has been abusive on this credit card.
That's never come up.
Okay, I'm asking you today. You're not suggesting, because I see it as an exhibit, that's why I'm asking you. You're not suggesting today that Ms. Minot has abused this credit card and charged unreasonable charges on it, are you?
No.
Okay.
She charges.
Objection non-responsive.
Okay.
After no.
Sustained after no.
Okay, sir, if you'll go to R4.
There's R4. Thank you.
Okay, can you tell me what R4 is for, sir? I can't tell what this exhibit is, what it reflects.
This looks like bank statements. This is my bank statement.
Can you tell me which bank statement, sir?
There's only one bank. It's called Wells Fargo.
Okay, so this would be, it's not one of those monthly statements. It's probably something you got online and printed out transaction. Is that fair?
Probably.
Okay, so if we look at it, for example, we can see that it looks like that American Express may have been paid on January 27th, 21, because that's the balances of the card. Looks like that was paid, correct?
All right.
All right. And then there was another American Express payment made of $4,302 in March 1. Is that accurate?
Yes.
Okay. And could you tell me what the check and the amount of $5,983 would have been for?
I got to look it up on my phone.
Take your time.
Objection, Your Honor, as to him looking it up. If you know, objection is to any source being looked at.
Sustained.
Don't look it up.
Put it down, please.
Your Honor, he volunteered to do it. How are you objecting to that at this point?
He's objecting to the predicate and sustained at this point.
Okay. So as we sit here right now, you don't know what that check was for. Fair to say, sir?
I can answer the question. It's nothing. I'm not
Objection
hiding anything.
non-responsive.
So
It's
Sustained.
it's
He's
something
just
in
asking if
relation
you
to
know-
objection
family.
non-responsive.
He's just asking if you know what that check was for, sir. It's a
Sir,
yes
I
or no.
don't remember, but I can certainly look it up. But
Objection non-responsive. He doesn't, after he doesn't remember. Your
all
Honor.
right, all right.
Chandler, would you find me their complete Wells Fargo statement? I'm missing something that I saw earlier. Okay, Mr. Minot, if you can tell me, and because we did not offer the interrogatories in today, how many vehicles do you have?
14.
And that 14 would be counting the cars the kids drive. Is that accurate?
That's correct.
And could you tell us, for purposes of clarification, by agreement, your son recently traded in a vehicle that was here 3 months ago. Is that accurate?
No, it's not accurate.
Okay.
He traded
Stop.
his.
Objection non-responsive.
Did your son, in the last 6 months, trade in a vehicle?
Yes,
Do you know what month he traded in the vehicle?
last month.
So between the time we were here at temporary orders and the time we're here today, one of the vehicles y'all had then is no longer in your possession. Is that accurate?
That's not true. No, still in,
Objection non-responsive after.
Okay.
this was agreed upon.
Sustained.
We have it in writing from Pamela that she authorized for us to do this.
Objection
Okay.
non-responsive. That's
Thank you.
Saying
Sir,
that
I'm not trying to trick you, sir. I'm just trying to be clear. Okay. Since the last time we were here and today, one of the vehicles y'all had back in November, you no longer have. Is that accurate?
Correct.
Which vehicle is that?
2019 Jeep Wrangler.
Okay. And as you were saying, that was everyone agreed that he could take that 2019 Jeep Wrangler and trade it for a different vehicle. Is that accurate?
That's correct.
Okay. So if the court was inclined to sell any property, that 2019 Wrangler is not available to sell, correct?
Right.
All right. Now, if we'll go to your Exhibit 5, sir, these are your Wells Fargo statements. What's that? I can't hear you, babe. Are you with me? I got them. Are you with me, sir?
I'm not yet. Hang on. Okay.
And it looks like the most recent one you've produced to us would be for February 12th, 2020. Is that accurate?
No, I've got March's too. I got it yesterday. But
Okay.
all right.
As
What's the
far
question?
as far as this exhibit that we're looking at, can we agree that it goes to February 12th, 2020?
Okay.
All right. And if we look at the balance of it on February 12th, 2020, you had $41,000 in the account. Is that accurate?
We
Your
don't know.
Honor, I'm going to.
Bank statement?
Okay.
What exhibit are we on?
I think
I don't have a
he's referencing R5, but R5 is an American Express credit card. So I think we're getting confused with our exhibits.
I'm sorry, Your Honor. I was looking at my exhibit, and I've been saying it's respondent's exhibit. I apologize for that, Mike. I wasn't. I can see why everybody was flipping out because that's really on me. So, Mike, for ease, I'm looking at Petitioner's Exhibit 5. Got it?
I may, but I don't think I do in this room.
Okay. I'll give you a second, Mike.
Let me get it offline.
I apologize.
All right, we're gonna go off the record for 1 second.
Thank you, Judge.
Oh, okay. I'll ask you then.
No, I'm just saying, it was
No.
charges that.
We're online. Okay. Okay. We're available, Your Honor, when you are.
All right, Ms. Broussard, your witness when you're ready.
Thank you.
Back on the record.
Mr. Minot, if you will turn to these, this exhibit is Bates stamp. Well, actually, if you'll turn to page 36 in the right corner, if you look at the right corner of that exhibit, it's page 36.
Okay.
And this is the last statement I've received from you, sir, dated November of 2020. Okay?
Right.
And this is the only personal bank account you operate out of. Is that accurate?
Yes.
So your paychecks go into this account. Is that accurate?
Yes.
All right. And the money that you have been ordered through the past order to pay to your wife or to myself or for expert fees, what account did you get that money from?
The same account.
Okay, so the $6,000 of expert fees, the $12,500 of attorney's fees came from this account, correct?
Yes.
And the monthly payments that you have been making to your wife come from this account. Is that accurate?
Yes.
And you didn't pay her anything for the month of April or March, or rather April. Is that accurate?
Yeah. Our agreement was finished by the end of March.
Right. So my question is, you didn't pay her anything for April. Is that accurate?
Objection, Your Honor, as to the reference, pay her anything. If we're talking about the spousal support, then that would be a specific item, but the word anything is overly broad.
Let me rephrase the question. Did you give your wife any direct monies of any kind after your last court-ordered payment in March?
No.
All right. You are aware she went to the hospital with COVID, aren't you?
I am.
And you don't carry health insurance on your family, do you?
Health insurance was under her name. She's the one who didn't.
Objection, non-responsive.
Sustained.
I'm going to tell you like the way it is. So, we don't have health insurance because of her, not because of me.
Objection, not responsive.
Okay.
Sustained.
How long have y'all not had health insurance?
About a year, I think.
Okay. So have you inquired as to what kind of bills she incurred at her stay when she had COVID in the hospital?
We're not in talking
Yes,
terms.
objection,
like
not
that. Yeah.
responsive.
So the answer is no?
No.
Okay. Have you inquired with her as to what, if any, bills she got from damage to the home during the freeze?
You broke up. I didn't hear the question.
Sure. Are you aware, do you know whether or not your home received any damage during our historic freeze in February?
It had some damage, gas line, and some issues. Yes.
Did you pay for repairs to any of the damage done to your home?
That wasn't what the judge said. Judge said she's,
Objection, not responsive.
So the answer would be no. Is that accurate?
right.
Okay. So out of this Wells Fargo, sir, and again, I don't have the benefit of having looked through what we have today. Do you know what the balance in Wells Fargo is today?
$4,900.
Okay, now you've paid the taxes on the property. Is that accurate?
Oh, absolutely.
Okay, and how much were the taxes, sir?
Objection as to which property is being referred to, Your Honor.
Okay, thank you. The residential property taxes, did you pay those, the marital home?
I have, yes, $33,000.
Okay, that's what I wanted to know. So, sir, I guess I'm a little perplexed because you don't have rental expense yourself, do you?
I don't have what kind of expense?
You don't have a rental expense, do you?
As of right now, I don't, but it's going to start next month.
I appreciate that. But right now, and since this balance has shrunk, you haven't been paying rent, have you?
No.
Okay. You don't have any car notes, correct?
No.
Okay. So
The amount of insurance bill.
Objection, non-responsive.
okay.
Same.
So your testimony today is all you have is under $5,000 in cash. Is that accurate?
That is accurate.
Okay. Do we have any other credit cards, sir, besides your American Express that have zero balances?
Bank of America, I haven't gotten a statement on it yet.
Okay. Do you know what the credit limit is on your Bank of America? I think it's already been admitted. I'll look for it.
We already talked about it for 20 minutes. It was $30,000.
Oh, you're right. I apologize. Thank you for correcting me. You have no credit limit on an American Express, do you?
I'm going to object, Your Honor. He does not have an American Express card.
Sustain.
Sir, do you have an American Express card?
American Express is under Pam's name.
Okay, so the answer is you don't have an American Express card.
I do have one, but it's under Pam's name.
So you're an authorized user?
I am.
And that's the American Express card that y'all put your children's tuition on, correct?
Correct.
And you do that because it's pretty smart. You get to use your points, don't you? Just pay it
I
off.
understand that. That's not my concern because
Okay.
that's what they accept.
Okay, well, if you pay the, all right, we'll get beyond that, sir. So, how much have you paid Mr. Tracton as we sit here today?
I don't remember.
Well, let's think about it. What was your initial?
You would know.
Objection asked and answered already, Your Honor.
Your Honor, maybe I can explore it a little bit.
You may.
Thank
It sounds like you're asking a different question, so you may continue.
Okay. Let me ask you this. When you pay Mr. Tracton, how do you pay him? What form, method?
Write him a check.
Write him a check? And which account do you write that check out of?
There's only one account. It's Wells Fargo. We can go back and forth on this. There's only
Stop.
one account.
Objection, non-responsive, Your Honor.
I mean,
No,
okay.
No, please.
Any other than Wells Fargo.
Yeah. There's only one account.
stop, please.
So you would write a check out of Wells Fargo to Mike, correct?
Correct.
Okay, what was your initial retainer check to Mike?
I don't remember.
Was it more than 15,000?
No,
Okay. Have you paid him more than 15,000?
I don't remember. I really don't remember.
That would be a pretty substantial payment, correct?
Objection, Your Honor, is speculative.
Okay, sir.
Sustain.
What is your primary vehicle? What is your daily driver, sir?
Jeep Wrangler.
Okay. Now you're only down to $4,000, correct?
Correct.
Well, how do you intend to pay Mr. Tracton going forward if you only have $4,000?
He's not getting paid. I've already told him.
Oh, you told him he's not getting paid. Okay.
Absolutely. I told him that yesterday.
Okay.
I
Sorry,
don't
Mike.
have it. If I don't have it, I don't have it.
Okay. Well, let's talk about what other assets y'all have, sir. Now, have you had an opportunity you don't want any further appraisals of your business we've established. Do you want the home to be appraised?
I know what the house is worth. Okay.
Okay.
I've done real estate for 20 some odd years. Okay. Yeah. Okay. Here's the deal.
Okay. Tell me.
I know what it's worth. We are where we are because of me. Obviously, it's normal. It's standard. I'm sure the judge knows that. I know what the house is worth, but Pam is throwing some crazy number out in the sky, which is not going to bring that. We will never be able to sell that house for that price. The house is worth 1.5. That's
Okay.
what it's worth. Now, if she wants to list it for
Objection,
2.8,
non-responsive.
that's a different. I don't know why she's listing it for
Objection,
that.
non-responsive.
Okay.
Saying
Sir,
after the house is worth 1.5.
sir,
Go ahead.
sir, do you want the house appraised?
I have to have it appraised because she doesn't know what she's talking about. Yes.
Okay. So the answer is yes, correct? Now you have responded to interrogatories and you put your own values on all your dirt, all your real property, everything, didn't you?
Yes.
Okay. Because you know what everything's worth, correct?
Objection, argumentative, Your Honor.
I'm repeating what he said. You know what everything is worth.
No, I know approximately how much it would be worth.
Okay. Well, if you're off 40%, maybe you're not as knowledgeable as you think you are.
Objection argumentative, Your Honor.
Okay, I'm sorry. I withdraw the question. Mr. Manu, have you understand that we have now appraised all but the house? Do you understand that?
No, you have
You
not
don't
appraised
understand.
all but the house. No, I still don't have the appraisal for the Highway 6 locations. I still don't have the appraisal for the Hitchcock location.
Okay.
No. You've gotten paid, but you
Objection
haven't
not
had them
responsive.
appraised.
Okay. I will represent to this court that all properties have been appraised. If that has not been supplemented, my apologies, because they probably recently came in.
We don't have it.
We supplemented that. Actually, Your Honor, they were sent over to the office this morning. Mr. Manu, would it shock you to know that the values you've placed on those homes, the properties that have been appraised, comes in $649,000 less?
I just told you approximately. I don't know. I'm not a real estate appraiser, but I got an idea.
Okay, but if you said you were worth 200 million or 2 million and now you're worth 2.6 million, you're pretty off the mark, aren't you?
Objection is speculative. Objection is argumentative, Your Honor.
I'll move on, Judge.
Sustained. Sorry.
Thank you.
Your Honor,
Stop, please.
can I just say something?
Objection non-responsive.
I know it's about something.
Wait for the
else.
next question. Mr.
Okay.
Mr. Traxton's going to be able to ask you questions and let you talk more in a minute.
All right. Sure.
Okay, so you would agree with me that as a savvy investor that you are, that generally real estate, and generally, if you say you don't know, that's fine, but you've said you were a savvy investor. Generally,
That's it.
Objection sidebar, objection mischaracterization of testimony.
No sidebars, just ask your questions, Mr. Broussard.
generally, real estate will appreciate at a greater rate than automobiles.
Objection, Your Honor, speculation as to his ability to know that specific answer when he was already testified. He doesn't know the answer to the real estate appreciation specifically.
Your Honor?
I understand he's not a certified appraiser, but I'm going to let him give an opinion as to his assets that he owns as far as whether or not he thinks they're going to appreciate or depreciate. So you may answer that question, sir. Do you think real estate will appraise? I'm sorry,
Appreciate, Your Honor.
repeat your question, Mr. Broussard.
Yeah, I got the
appreciate it.
question.
Less
Answer is
than-
no.
You would agree with me that
Yeah, answer is no.
the answer is no. So you believe your cars are appreciating at a greater rate than real estate, correct?
Objection, Your Honor, as to when we're talking about dollar value in collectibles, it's not a comparison that you can make.
Mike, you're testifying for him.
Overruled.
So what you're saying is that your cars, sir, appreciate at a greater rate than real estate.
Some of them.
Okay, which ones appreciate more than real estate? Let's identify them.
Your Honor, I'm going to object to this line
Yeah.
of the questions as to being relevant or not relevant as to where we are in this case and what's being asked for.
This,
Your Honor,
I understand where you're going with Bruce.
Okay.
But the court has a fairly good grasp of what appreciates, what depreciates, and
Thank
and
you, Judge.
so if you can just ask him specifically about certain cars, if he thinks there's certain cars that should be off limits because they're going to appreciate, and we can handle it that way, please.
Yes, that's where I was going, Judge. Thank you. Mr. Minot, out of your 14 cars, first of all, tell me which one would you consider your daily driver?
Jeep Wrangler.
Look at the microphone.
The Jeep Wrangler is your daily driver.
Yes.
And out of your 14 cars, if you know, which one would you consider to be Miss Minot's daily driver?
2018 Mercedes S63.
Okay. So then do you want or do you not want to sell either of those vehicles?
I'm not selling any vehicles.
Okay.
Objection not responsive.
Okay, I'll follow up, Judge.
Mhm.
So of the 14 vehicles that you have, you are unwilling to sell any of those vehicles, correct?
Absolutely. I own them like they're
Objection
my
not
babies,
responsive.
and I will not sell any of them.
Sustained after absolute.
Okay. if the court were to select some vehicles to be sold, do you have a preference, if you've been ordered to, as to which vehicles you would like sold?
No,
Objection asked and answered as to his desires on the sale of the cars, Your Honor.
Absolutely not the same question.
Overruled, you may answer that.
So you don't have a preference to which ones would or would not be sold.
none of them will be sold.
Okay. So you will defy it. If a court orders us to do it, you're not going to sell them, is what you're telling us?
Objection, Your Honor.
That's
I'm not
not
going to
what I
have
said.
my client answer that question. And I'm going to advise him to take the fifth so he doesn't get himself in trouble here.
Your Honor, all I'm trying to establish is that if the court does so, I'm trying to give Mr. Manu an opportunity to preserve any of the cars that he might want to preserve. But if he doesn't want to take
You've given him
that,
that opportunity.
thank you, Judge.
You've given him that opportunity, and we're not in an enforcement, so I'm not going to make him answer questions about whether or not he would defy a court order.
Thank you, sir.
You may continue, Mr.
Sure. Mr. Minot, do you plan on taking any distributions from Glamour Girls in the next month or two over and above your salary?
We're in
Just yes. sir.
negative.
Objection.
No,
Okay. And sir, have you received your tax refund?
no,
Okay. Are you expecting a tax refund pursuant to Exhibit 2?
yes,
Okay. That refund's going to be approximately $10,000, sir?
yes.
Do you know when you filed approximately?
3
Last
weeks
you
ago.
filed these on March
3
23rd.
weeks ago.
Okay. All right. And so, sir, have you received, I know we talked about a PPP loan to the business. Have you applied for a second PPP loan?
Uh-huh.
I'm sorry?
That's how we're open, because we got a second PPP loan.
So you've had two.
Correct.
Okay. And you recently got the second one, correct?
February.
Okay. Between the last temporary orders hearing and this temporary orders hearing.
Mhm.
Okay.
Yes.
Have you applied for an EDIL loan also?
Don't even know what that is.
Okay. It's called an Economic
Never heard of it.
Disaster Entry Loan.
I've never heard of it. Answer is no.
The answer is no. Okay. So have you applied for any other personal loans of any kind?
No.
All right. So what is your plan then, sir, going forward on how you're going to just pay for yourself if you're only bringing in this, I think you said 5,000 a month?
Yeah.
How do you,
Explain something? Can I explain
I'm
something?
just asking what your plan is to go going forward, how
I
you're
had
going
a
to,
plan and I'm about to explain it if judge would allow me to.
yeah, absolutely.
So
Sure.
about a month ago, I called Pam. I said, Pam, whenever the appraisals just started coming in, I said, listen, these two lots, they're bringing some good money. There's no lots left in that area. Let's put these up for sale. And she's like, why? I said, because we don't have any money.
Mhm.
She doesn't know what comes in, what goes out. She has no idea. I pay everything, okay?
Mhm.
I told her, listen, I'm going broke. I don't have any money. Let's put these properties up for sale.
Mhm.
At the time of the closing, we'll split the check half and half. Half of the check will go to you, half of the check. She's like, I'm going to have to get back with you on this. I said, that's fine. Never got back with me. That was my plan, to answer your question.
Okay. So your plan was to sell real estate instead of cars, correct?
Absolutely. Absolutely.
Thank you.
My cars are like my babies. Ain't nobody going to sell.
There's not a question on the floor.
Sustained.
Your Honor, I have no further questions for this witness, and I'll pass the witness.
Mr. Tracton, your witness.
Thank you, Your Honor. In the Glamour Girls business, based on your knowledge of those fees that were talked about in the beginning, do you remember the fees the girls pay when they come to make a payment at the front door before they go there?
Yeah, they pay $20.
Objection, non-responsive. Do you remember that amount you said, $20?
Yes.
And that $20, who gets that $20?
It gets split between bartender, manager, and the DJ.
Are you a bartender, a manager, or a DJ at the business?
No.
Okay. So you don't get any of that money then?
No.
Objection, leading.
Sustained.
You've been running the business for 20 years, is that correct?
Yes, sir.
And in the 20 years, has Pam been aware you have this business?
Yes.
And how many times has Pam been there to help you out in the last year while while COVID is taking place?
Never.
To your knowledge, does Pam have any degrees? Education?
Yes.
And what type of degrees, to your knowledge, does she have?
2 master's degrees.
And what area are they in?
I believe one is art and I don't remember the other one.
Were they earned during the marriage?
No.
Prior to the marriage?
Yes.
Okay. When you were in court in November, and as counsel brought up that you remember testifying that the status of your business was that you expected the state to put chains on the front doors. Do you remember that?
I do remember that.
And to your knowledge, have they put the chains on the front doors?
Not yet.
Do you know why that changed since the time that we were in court last time?
The judge gave us a temporary order till we go to appellate court.
Okay. And do you remember what the purpose of that temporary order did for y'all, for the business?
Kept the doors open.
Okay. And Mr. Broussard has implied regarding the earnings being made by the business. Is the business making a positive or negative cash flow, if you know the answer?
Your Honor, I'm going to object to cash flow on the business as Mr. Manu's those documents have all been requested and he hasn't produced one document in support of that. I'm going to object to that line of
You
questioning.
need to go through my
Objection,
business.
non-responsive.
You need to go through
Hold
my
on.
business attorney
Overruled.
for that.
Hold on, sir. Just
Yes.
let me rule once there's an objection on the
sir.
floor.
Yes, sir.
Overruled.
Sorry.
Testify if there's a positive cash flow for the business.
No.
And how has the business then been able to survive until today? Where the money's coming from?
I got a PPP loan in
Okay.
February.
Is there enough money in your personal account or any cash account that you have to be able to pay for an appraisal out of the community funds of the business?
Absolutely not.
Do you have $17,000 in cash in any accounts?
No.
In regards to the business, is there enough money to, if you know, just to draw it out of the business and pay yourself a larger amount of money?
No.
Would that be a good business decision of yours if you were to try? I'll strike the question. You're renting a home from your friend, you said, correct?
Yes.
That friend, you said it was paid in June of 2020,
I think so. Yeah.
and that was before or after your wife filed for divorce,
Before.
okay? And when you made that payment in a lump sum, was that a attempt to drain out the accounts, the personal accounts at that time?
I'm going to object to continuing leading questions. I've been letting them go on, but he's been leading them for about 10 minutes now.
I will.
Sustained. Don't leave
rephrase-
your witness.
I'll rephrase the question. Have you made any attempts to try to cause your wife financial harm by draining out your personal accounts?
Objection leading, Your Honor.
I would never do that. I would never do that. Okay?
Objection.
That is not.
Objection sustained.
You testified in regards to R6, which is the Bank of America Visa card. Do you remember talking about that card?
Yes, sir.
That's the card. Who uses that card?
90% my son.
Who does the other 10%?
Myself.
Okay, and the funds that on that card, if you don't make a payment each month, is what happens to the balance of those funds that are owed still?
I don't want to pay any interest.
Is there interest charged on them?
If I were not to pay it, yes.
Okay, that's my question.
Yeah.
Thank you. On the American Express card that was testified to as R5, that is in your wife's name.
All right.
If you didn't pay, who pays on that card every month?
I do.
And if you did not pay on that card each month, do you know if Miss Manui could pay on the card? If you know.
I don't know.
Prior to our last hearing, were you aware of funds available, Miss Manui, to pay on the card herself?
I'm sorry. What was the question again?
Prior to our November hearing,
Okay.
were you aware of any funds available to your wife to be able to make payments each month on the American Express card?
The money that she took out of our safe.
Objection, Your Honor, leading, objection non-responsive.
Overruled.
Now, Mr. Manui, at the time that you and your wife had separated, was there money at the house that disappeared?
Yes.
What was the approximate amount of the money that disappeared from the house?
$130,000.
And do you recall about when that occurred?
June, sometime in June.
Is that around the same time you moved out of the marital residence?
Yes.
When you moved out of the marital residence, did you take any of the money of that $130,000?
No, gone.
Where was it taken from?
Our safe.
Okay. And did you know the combination?
Yes.
Do you know of anybody else that had that combination or access to the safe beside yourself?
Myself and Pam.
If you didn't take the money, did you discuss with Pam where the money might have gone?
I mean, I asked her. She said up till today, she thinks that she did the right thing. She told me the other day, about a couple of months ago, I'm so glad I did that. I did the right thing. No, I don't
Okay,
know.
objection, no
Yeah,
response.
anyway,
At any time between November and today, any time that your wife has admitted or denied specifically to you that the money was taken by her?
yes,
And did she admit or deny it?
admit it.
Okay. Did she tell you, do you know where she put it?
No,
Did she tell you where she put it?
no,
Was there a period of time other than when the court ordered you to pay support between between the period of June when you moved out and when we were in court in November, was there a period of time that your wife was making payments on anything from sources other than you that you're aware of?
no,
No.
none.
Objection, asked and answered.
Sustained.
You thinking?
Yes. The 14 motor vehicles that you have possession of, are any of those used by your children?
Yeah, sure. Three or four of them.
Okay, and those vehicles being used by or in your children's possession, your wife, is she aware or not aware of them?
She's aware of it.
Okay, and when we say it's in their possession, is it vehicles, how do you classify? Did you give those vehicles for them, or are they your vehicles you do what you want with?
I got that for them.
Did your wife ever tell you that you should or should not give them those vehicles?
Objection, leading.
Alternate questions, Your Honor.
Overruled.
Did she object to you getting those vehicles for them at any time that you're aware of?
No,
In regards to the damages to the home from the freeze, do you know where the source of funds, let me rephrase that question. Do you remember when the freeze occurred?
I do.
When was that?
End of January.
And when the freeze occurred, were you or were you not making payments to Pam each month for spousal support?
I was.
And do you know if those funds were available for the purpose of making the repairs?
Nothing happened to the house. Might have cost $100 to fix it.
Um, Did Pam make you aware or give you awareness of what damage was made to the house?
She told me there was no damages done. There was a little gas leak. I don't even think that had anything to do with the freeze. That's when it was noticed, but they came and fixed it.
And do you know whether or not that was an expense that you incurred or not, or that was?
I don't
covered?
even know how much it cost.
When are you due to be paid next time?
2 weeks from now.
And on the properties that are just land, just lots, are there any extraordinary expenses that are incurred on those lots that you have to pay other than the property taxes?
The 2 lots that are suggested to sell are the lots that the homeowner association
Non-responsive, Your Honor.
crazy.
Oh,
Okay, they're driving me
well,
crazy. I want to get
objection,
rid of them.
non-responsive.
Okay.
are there any lots that you and Pam own together that have extraordinary expenses on them?
The 2 lots that are offered to sell were
Okay, and what is the extraordinary expenses related to?
homeowner association and cutting the yard, their acreage land, and the HOAs keep sending me certified mail, do this, do that.
Okay.
I want to
and
sell them and get rid of them. I'm
objection
making money on
non-responsive.
it.
Objection non-responsive.
Sustained.
Thank you, Your Honor. Will it benefit you and the community funds if you were to, as you propose, sell those as soon as you can and split the proceeds?
Yes, sir.
And do you believe that they would bring a good value without having to spruce them up or do anything to make them to be sold?
Yes, sir.
Do you have to put any money into them to sell them?
None whatsoever.
Can they be put on the
Your
market?
Honor, I'm going to object. There's been no
Yes.
pleadings to sell these properties from Mr. Tracton.
Your Honor, it's already been brought up as to sell things other than the marital residence. I'm just following Mr. Broussard's.
I'm going to allow,
I'll withdraw.
I'm
it.
going to allow the questioning. You may continue, sir.
Thank you. Those 2 lots, if you were to estimate an amount that they might bring to you and to Pam, what would that estimate be?
I think that both of them would sell for about $150,000.
Is that each or together?
No, together.
Okay.
Gotcha, though.
And both those had appraisals done on them recently, correct?
Yes, that's how I noticed how much they're worth.
Okay, so you're using the appraisal numbers as your estimate?
I mean, I knew it's close to that area, but the appraisal came up way higher. So
So you'd benefit by that? And do you know if you and Pam would benefit by that?
yeah, we would quadruple what we paid for it.
Okay. Is there anything easier or better to sell based on your estimation of the properties that you have that would not cost you as much to get rid of?
That would be the best plan. I mean, I've handled this family for 20 some odd years. I know when to buy, when to sell. This is the time to sell.
Okay. Are you agreeable to selling any of the motor vehicles that are identified as part of the 14?
I would die before I would sell anything
Is there a reason why those cars are important to you?
because they're like my kids.
Okay.
I've looked for years to find each one of them.
Okay, and do they have a value other than the buy and sell value to you? To
There
you?
might not be much value. It's just they're my babies. I'm not going to sell them.
As your babies, do they have a value different than what they might sell for to
Yes.
dollars and cents?
Yes.
Thank you. Has Pam addressed with you her efforts to get a job?
Right cleaner here right now.
No.
Okay. Have you discussed with her?
I didn't hear the answer to that. Hold on, Mr. Tracton, I didn't hear the answer to that. Sir, did your wife express to you her efforts to locate a job, yes or no?
No.
Now, does your son, since we've been in court last in November, has he gotten a job?
Yes, he's working as an engineer.
Okay, and is he making any help to try and buy or assist in the financial matters that impact him?
Yes, he's paying his own car payments.
Okay, now, there was a discussion that took place in an earlier testimony that he traded in one of the motor vehicles that were part of the 14.
Correct.
Is the vehicle that, the replacement vehicle that he has now, is that his, or is that also one of the four?
No.
Now the replacement of the 14th?
I co-signed for him because I want him to build some credit. So it's under my name and his name.
How old is your son?
21.
Is the title in your name or his name?
Both of our names. When you co-sign, it's under both names.
Is your son completed college yet?
No,
How much more does he have?
about 2 more years.
Okay, and is that toward, what type of degree is it toward?
Mechanical engineering.
Okay.
What year was the
There was a
regular?
question about your knowledge of your wife's COVID period of time. Are you familiar when she had COVID?
It was around the time that it was actually the day that we had court last time. That day she had COVID.
Okay, and did she contact you in regards to the COVID that she had?
She never did. My daughter told me a few days after.
Okay, and when you learned of the COVID, what did you do? Let me rephrase
called
the
her.
question. Did you make any attempts to contact Pam at that time?
Oh, absolutely. I was in contact with her every day, several times. Wanted to make sure she's okay. And she ended up going to the hospital.
Okay, when you say you were in contact with her, did she initiate a call to you or did you initiate the call to her?
No, I called her
Okay, and why did you do that?
because I wanted to. Pam, you're shaking your head. Did I not call you?
Objection, non-responsive.
Okay.
In regards to the cost related to the COVID that she incurred, did she ever discuss with you whether it was paid for, how it was paid for, if she paid for it at all, or if it cost any money?
She asked me if I would help her pay the bill. I said, I certainly will help you. But what caused the problem, what caused the fact that I did not help her was, Your Honor, please hear me out on this particular issue,
Objection,
if you don't mind.
objection, non-responsive.
Can we just
Sustained.
talk?
No.
You said staying? So can I talk about it?
Is
Right.
there a reason that was occurring at that time that you wanted to have this conversation with Pam about her well-being?
I don't remember.
When did Pam contact you regarding the maintenance on the house while she was in the hospital?
She did.
And what did you do?
I paid all the bills while she was in the hospital. And I never deducted it from her $4,000 checks.
Okay, so did you pay money over and above the $4,000 that was being paid to Pam as spousal support? Did you make payments over and above that on her behalf or directly to her?
On her behalf, yes.
Were those bills that the court had ordered you to pay from the temporary orders hearing, to the best of your knowledge?
No, I did that because she had COVID. She wasn't able to leave the house. So I took care of all the bills.
Are you in a financial situation now that you could do the same thing if it occurred again?
I swear I'm not.
Yes or no?
I'm not. No. Answer is
Thank you.
no.
Okay. I pass the witness.
You didn't.
Briefly, Your Honor. Well, I guess not briefly.
I have a real quick question. We keep mentioning 2 lots. Where are those 2 lots, sir?
Sir, these lots are in subdivision called Sun Creek Ranch. They're in Rosharon off of 288. That area is growing. I bought these lots about 2008, I think, when the economy got tanked. I ended up buying some lots there, and I paid dirt cheap for them, and they're worth a lot of money. That's how I've made a lot of money past 20 some odd years, not just from the club. I do a lot of real estate transactions. I know when to buy, when to sell. This is the time to sell. These guys, they've changed their homeowner association. They are driving me crazy. Every 2 weeks, they're sending me a certified mail, cut the grass. Well, you cut the grass, I'll pay for it. And then they charge me a $250 fine for cutting the grass.
All right.
I would like to.
Thank you. I heard that testimony.
Thank you.
Mr. Broussard.
Mr. Minot, you said that your kids are operating 4 vehicles.
Yes, they are.
Do you think it's necessary for your children to have 4 vehicles?
Yes, it is, because I love
Objection,
them.
non-responsive.
Objection, non-responsive.
Yes, it is.
Okay, and when your son traded in one of the Jeeps, that Jeep was paid for, is that accurate?
Yes, it was.
Okay, did 100% of the trade funds go towards the purchase of his new vehicle?
Of course.
Okay, and you talked about your babies that you've been searching for them for a year. Not one of these cars let's see, outside of maybe that Honda, none of them are more than 5 years old, correct? Outside of the Honda or the Nissan? Let me just pass that.
You have the list of all the
Objection,
cars.
non-responsive.
Sure. You've got 4 2020 models, correct?
I don't know.
Okay.
The list.
And,
I can look it up if you want me to.
Objection, non-responsive.
okay. And
Sustained after auto.
all these vehicles are paid for, correct?
Not the last one that we just purchased.
Well, that's your son's vehicle, correct?
Correct.
And you testified he's paying for that.
That is
Correct.
correct. But that's not the question that you asked me.
Okay. Thank you for correcting me.
Yeah, of course.
Feel free anytime.
I will.
Your insurance on these vehicles, there's quite a few cars to insure and they're high dollar cars, correct?
Yes, sir.
Kind of like mowing grass at a subdivision, right?
Objection, Your Honor, as to the
Irrelevant.
relevancy of the question or the argumentative nature.
Overruled. Argumentative sustained.
Okay. You would agree that if we got rid of some of these cars, we wouldn't have to pay insurance on those particular cars, correct?
You're wrong. You're wrong. I got insurance through Haggerty. I've got them so
Wait a
cheap.
minute. Objection. Objection, non-responsive.
Sustained after wrong.
So your testimony is that you will pay insurance on a car that's sold?
No, that's not what I said.
All right, well then if you'll listen to my question, maybe we can get there.
Sure.
You would agree with me, and I'll just pick a car, okay? The 2018 BMW M3. There's no note on that, correct?
No.
Are you telling me that that car is going to appraise and going to increase in value?
Absolutely. That's the last year they made the V8. You don't know nothing about cars. I do.
Okay, thank you. So if you sell that car, then that is a car that's well sought after, isn't it?
That's my son's baby. No
Okay.
one touching that car.
Okay. You would agree with me that that's a hot car, that people want that car. You're telling us it's
That's
Objection, Your Honor, as to the argumentative nature. He's asked and answered. The
You know what,
question-
Judge? I beat a dead horse on these cars. I'll go past them.
You are.
Thank you, Mr. Minot. Thank you for your input.
I overruled the objection. The next question, Mr. Broussard.
Okay. So you've testified, your lawyer was asking you about how many times Ms. Minot had been in the office since she filed divorce against you, correct?
Yes.
Okay. By the way, how long had you been out of the house on your own before she filed for divorce, sir?
I had a meeting 2 weeks prior to her filing a divorce, and I told her that I'm leaving. Our divorce has been
Objection,
going on for 18
non-responsive.
years.
Okay.
I just waited for the kids to grow up.
Objection, non-responsive.
Okay. So you were ready to divorce her, correct?
18 years ago.
Okay, you've been ready to divorce her for 18 years. Now, is it fair to say that, because Mr. Tracton was asking about her involvement with the club, you don't allow her to be involved with the club, do you?
Okay.
Objection.
She calls it a whorehouse and a titty bar, and she puts me down in front of people every day, makes fun of me every day. You think she would come in that place? But when she wants a $200,000 Mercedes, she comes and sees me.
Mm-hmm. Okay.
Yeah.
Well, You don't want to talk about visiting prostitutes or anything like that, do you?
I didn't hear you cut up.
Well, you mentioned a whorehouse. My question is, do you want to get into a line of questioning about
I just
visiting
answered you.
prostitutes or anything?
Not right now.
Okay, I didn't think you did.
Yeah, it doesn't matter.
Objection, non-responsive and irrelevant.
Just want to know where he was wanting to go with this, Judge. So back to my initial question, because Mr. Tracton was asking about her involvement in the business. You would agree with me, she's got zero involvement in the business, correct?
Correct.
Okay. She's never worked for you, correct?
No.
And you're not suggesting that she should earn her keep by working at the business, are you?
That's not something that I'm going to suggest.
Okay, I just want to make sure.
Yeah.
And you're not ready to let her, you wouldn't even let her in the business to look at any of the records or anything like that. Is that accurate?
That's not true. She's never had any interest. She doesn't want to come in. She don't even, no,
Okay.
that's not true.
Okay, so is your testimony that you will allow her in the business to view the records and see what's going on over there?
I'm going to object, Your Honor. He's trying to negotiate with the witness.
I'm trying to understand what he expects her to do, Judge.
The answer is no.
I'm going to sustain that. He said that he doesn't want her working in the business, so I'm
Okay.
going to sustain it.
Sir, to your knowledge, when was the last time your wife worked?
Probably 4 years ago for about a month and a half.
Okay. And would you agree with me that primarily she's raised those kids and taken care of those kids?
My kids, she forced me to put them through Kincaid, which is a private school. I went through hell for 12 years for each one of them, paid tuition of 60 some odd $1,000 a year. I took them to school every morning, brought them back home every afternoon. Yes, there was times that I had a meeting or whatever. She had to do it. She never said no. I took care of the kids 70%. She took care of the kids 30%.
Okay.
It's the fact. Okay.
Okay, well, no, I'm just trying to get the facts here.
Yeah, no problem.
So basically, you're just saying that you were super dad. You did it all, correct?
I was.
Objection,
Everybody else calls me a super dad.
Objection,
Yes.
non-responsive, objective, objection, argumentative.
No further questions, Your Honor.
Mr. Tracton, any redirect of your
I've
client?
never seen anything like this in my life.
Objection to sidebar, Your Honor.
Sustain, no sidebars, Mr. Bruce.
I apologize, Judge.
Mr. Tracton, do you have any questions?
Mr. Manui,
Yes.
did you file for divorce in the 18 years that you were referring to in your prior responses to Mr.
No, I was hoping for things to get better and better and better. I just didn't want to do that to the kids.
And in that period of time, did you, during the time that you were in the 18 years of up until your wife filed for divorce, was there times that she discussed wanting to work with you?
She always discussed working. I always told her fine.
Okay. And when you say always, how did your wife follow up and tell you what she wanted to do as work?
No.
When your wife, you said she earned her degrees before you got married?
Yes, sir.
Okay. Do you know if your wife was working before you married her?
Yes.
Do you know what she was doing at the time?
She was a school teacher.
And do you have any reason to believe that she could or could not get a job as a school teacher today with 2 master's degrees?
Of course not. Anybody, I mean, she can get a job if she wants to.
And since January 1st of this year, are you aware of whether or not that, let me rephrase the question. You remember in November of 2020, when we were here last, that Pam had testified that the house was still being occupied on weekends by your children?
Yes.
And since the time of the last hearing, has that situation changed to your knowledge?
Yeah, both kids have gone to College Station. They live there now.
And during the holidays, do they return back to your marital home?
I don't remember them doing that.
Well, let's use
I think
Christmas
Pam,
time.
I think Pam went there, if I'm not mistaken. I really don't remember, Michael.
When your children are in town, do they visit you?
Your Honor, I guess we're getting off track here. I'm going to object to relevance at this point.
I go visit them.
Objection relevance, Your Honor.
Sustain.
Your Honor, the line of
Same.
questioning goes to the occupation versus of how many people live in that house?
Your Honor, we have an,
I understand. We've got an agreement. Hold on. We've got an agreement to sell that house. We're going to work out the details, and I'm going to give y'all a date for a hearing on that if y'all can't work out the details. But we've got an agreement to sell the house. So I think
Okay,
we
Your
can
Honor,
move
thank
on.
you. Pass the witness.
no questions for the witness, Your Honor.
Mr. Bruce.
You did not.
All right, thank you. We're going to go ahead and break for lunch then. Why don't we resume? Lawyers, would it be easier for y'all to resume at 1 or is 1:30? Normally I do 1:30, but
One's fine with me, Judge.
looks like y'all are about an hour and a half in. So my guess is if we start at 1, maybe y'all will be done by 2 o'clock. Y'all want to do that?
That would be my
We'll
preference.
resume at 1 o'clock.
Thank you.
Thank you, Your
Run
Honor.
off the record.
Thank you.
Don't say anything until I get off, until I get our machine disconnected. And then I'll explain things to you.
That's good. Oops.
5, so.
They?
Yeah.
Okay. Yeah.
Don't forget the date that we had.
Oh, no. Hold on.
Okay.
All right, Mr. Broussard, we're back on the record and you may call your next witness.
Thank you, Your Honor. I'd like to call at this time Ms. Pam Minow.
You may proceed.
Thank you. Ms. Minow, you heard some testimony regarding your of what perceives to be a lack of effort to find employment. Can you start by give the court some idea of what you've been doing to search for employment?
I have applied to every school district within the area: HISD, Fort Bend, Lamar Consolidated, Manville, Stafford, maybe missing something, but these are all the different school districts I have applied to. I've been to numerous job fairs. I have contacted some people that I know in car business to see if I could go back to car business. I don't have anything yet, but I'm hoping to find something soon.
Okay. And ma'am, with regard to your statement that you've been to numerous job fairs, in light of our current pandemic, can you describe what type physically those job fairs you went to were? I can probably do better, ma'am. Did you personally go to job fairs?
They were on Zoom.
Okay, virtual job fairs.
Yes.
Okay, and through your job fairs and through your employment, did you get opportunities to view anyone's resumes that you would have been applied against?
Yes, every person that
Okay.
commented.
Without telling me what those resumes said, what was your perceived impression of the resumes that were submitted for a particular job versus yours?
They were quite a bit better than mine, whether it was with more certification or whether it was with
I'm going to object, Your Honor. It'd be hearsay for her to know what anything on those documents would have been.
She's okay. So, ma'am, have you been offered a job anywhere?
I haven't even been called anywhere.
Okay, ma'am, Mr. Minow spoke extensively about your heartfelt confession to absconding with $130,000. Did you hear that testimony?
I did.
Okay, ma'am, can you tell the court if you have ever made an admission to Mr. Minow to that effect?
No, because that never happened.
Objection now responsive after no, Your Honor.
We'll go for it. Ma'am, did you ever take that?
No, I did not.
Ma'am, did you see Mr. Minow, or were you aware of money missing from that safe?
Yes, he was spending it.
How did you become aware of money missing from the safe? When did it start?
When we were talking about divorce, he bought the yellow Jeep and he spent money on the club, and he paid for
Objection now responsive, Your Honor.
his rental place. And I don't know.
Wait for the next question, ma'am.
Okay, ma'am, without telling me what he spent, I want to know, did you notice the funds in the safe deposit? Did you notice them being depleted?
Yes.
Okay, over what period of time were they being depleted?
I think she froze up.
I'm still on.
I know, Mr. Trackman, we're not having any issues on yours this day. It's the other side.
I've been preparing for
Mr.
this.
Broussard, I think Mr. Broussard's frozen as well.
I think they're both at the same location, Your Honor.
Mr. Broussard, if you can hear me, y'all may want to log off and log back in. Maybe that'll fix the problem. We're going to go off the record while we deal with some technical difficulties with Zoom. We're off the record.
And did Judge Bell let you in? Judge Bell let you in? Scott, she's on, Judge Bell. She's on with Judge Bell.
You unmute yourself.
I was about to say we're hearing everything. Oh, they're moving over to his.
Judge? Your Honor, can you hear me?
I can.
Was that me and I was the only one that was out, or did Zoom drop us?
No, it was just you and your client that froze up.
Okay, well, I'm going to sit in the room here with her, Your Honor, if that's okay.
That's fine.
Okay. I'm sorry.
No problem. We have this, it comes up periodically. It's just one of those things we have to deal with.
I know it performed so well all morning. I was really shocked. Okay, and Ms. Minow, I'm going to
One
get.
second. We're going to get back on the record when you're ready. Just let me know when you're ready.
Thank you.
The court's back on the record in the Minow matter. We were on the direct examination of Mrs. Minow by Mr. Broussard. We're going to pick up where we left off before we had those technical issues. Mr. Broussard, your witness.
Thank you. Ms. Minow, I believe when I last was questioning, I was questioning about the money from the safe. At some point, did you take money from that safe in the last year?
I did
And how much do you estimate you took from that safe?
about 20,000.
And when do you think you took that 20,000?
That was the last 20,000 that was left in the safe.
No, when, ma'am, when?
Oh, maybe May, June
Of 2020?
last
Well,
year.
we're not
Yeah.
even in,
Whatever year it was, I don't
Last
remember.
year?
Yeah, last year.
okay. And can you tell us why you felt the need to do that?
Because I knew he was wanting to leave. I didn't have a bank account. I didn't have anything. I was scared.
And ma'am, out of that, you initially gave me a retainer of $5,500. Where did that money come from?
From that money.
Objection leading, Your Honor.
Okay, ma'am, how much did you retain me for?
I don't remember.
Okay, where did you get the retainer from?
From the money that I had taken.
Okay, thank you. Now, ma'am, let's get back a little bit to your lack of employment throughout the marriage, because I believe that Mr. Minow said he took care of everything, including the children. How are you?
Characterization of testimony.
I think it's dead on, but if you want, I'll withdraw the sidebar. Ma'am,
Abstain.
can you tell us, ma'am, what level of education and training you have?
I have a bachelor in speech communication, and I also have a teaching degree.
Okay, so your first degree would have then been speech? Or,
Yes,
and then you went
communications.
from communications and got you a teaching cert, correct?
Yes,
Okay, so we don't have masters, we have a teaching certification. Is that accurate?
yes.
Okay. And ma'am, when did you teach school? When was the last time you taught school?
Before I was married.
Okay. And you worked in the automobile business, is that accurate?
Yes,
Can you tell us what you did there?
I was a finance manager.
And when were you doing that?
I did that maybe about 10 years ago. And then I recently had a job about 3 years ago.
Okay. So, so have you looked into those industries to attempt to gain work also?
Yes,
All right. And ma'am, you and I have, without talking about them, we've talked about some of the manners and things that need to happen to resolve a divorce case, correct? Without anything specific, correct?
correct.
All right. And do you believe that to adequately value your estate, that Glamour Girls needs to be appraised?
Objection leading.
Sustained.
Ma'am, what are you asking the court to do regarding Glamour Girls?
I want to know what it's worth.
Okay. Ma'am, do you have the funds to retain an expert to do that?
No, I don't.
Okay. And so what are you asking the court to do today so that you can accomplish that?
Help you financially.
Okay. Well, you understand that Mr. Rick Bell, Judge Rick Bell, can't give you any money out of his pocket, correct?
Correct.
All right. So you're asking that money come from the marital estate. Is that accurate?
Correct.
Ma'am, do you have any resources to continue to pay your monthly expenses?
I do not. I have several bills that are waiting to get paid.
Okay. When you, and I don't remember the amount. Do you remember the amount that has been previously ordered for your husband to give to you monthly for payment of those bills?
4,000
Okay. And when he would give you that 4,000, where would that money go?
to the bills.
Okay. But physically, where did you put the $4,000 check?
I would cash it because some of the people that I had to pay, they come to the house. I-
Objection, I'm responsible for that, Your Honor.
Okay. Yes, sir.
After
Sustained after
suspension,
I would
cash
cash
it.
it.
Ma'am, what did you do to pay your bills in April? Did you have any money to pay your bills?
No, I have a lot of bills waiting to get paid.
Okay.
Objection, I'm responsive.
Have you had to, how have you lived since, when was the last time Mr. Manu gave you any money?
At the beginning of March, I believe it was.
Okay. And do you still have any of that money?
No,
So what have you had to do because of that?
borrowed some
Okay.
from family.
All right. Now, ma'am, you've heard your husband testify that basically y'all have $4,000 in the bank account, correct?
Correct.
Right. So are you requesting that the court liquidate some assets?
Yes,
And what kind of assets do you think should go first?
maybe some of the cars or some of the properties.
Okay. So if we're talking about the cars, ma'am, what car do you primarily drive?
The S63.
Okay. You're not asking the court to sell that one. Is that accurate?
Correct.
Objection leading, Your Honor.
Okay. What car does your husband? I'm
I'm
sorry.
gonna allow it since it's dealing, but I'm gonna allow the leading when it's dealing with requested relief because it's just easier. So overall, you may continue.
Thank you. Ma'am, are you, we heard your husband testify that he primarily drove, I believe, the remaining Jeep. Is that accurate?
Correct.
So you don't want that one sold. Is that accurate?
Correct. If that's the car he drives,
That's
yes.
the car he's driving. What car does your daughter primarily drive?
She drives a white Mercedes SUV.
All right. And what year is that white Mercedes SUV?
It's a GLC 43. I'm not sure what year it is.
Okay.
It's
Do
maybe
y'all have
2 years
more
old.
than one GLC 43?
No.
All right. And your son apparently has a new Ford truck. Is that accurate?
Correct.
We don't want to sell that after. do we?
Correct.
All right. So, ma'am, are you requesting that the court continue the monthly stipend of temporary orders as previously ordered?
I need that.
Okay.
Objection not responsive, Your Honor.
Sustained.
Yeah, he's right. You said I asked you, are you asking him to do that?
Yes.
Okay, there you go. And ma'am, if we have to, if there's no money, would you agree that we either have to sell some things or we have to go charge some things, correct?
Correct.
All right. Ma'am, have you done anything in your mind, okay, just in your own opinion, over the last 3 months that you would consider wasteful spending or regretful or things that you shouldn't have spent money on?
Absolutely not.
Okay. Now, ma'am, there was some talk about your jewelry. Do you want to sell the jewelry at this time?
No, I don't.
Okay. Ma'am, your husband went on for an extended period of time about doing everything during this marriage and should have divorced you 18 years ago. How's that make you feel?
Objection is relevant to this matter, Your Honor.
Your Honor, I'll let him talk about it for 5 minutes.
Well, it's sustained for temporary orders. That's something that that would be relevant in the final, but I'm going to sustain it for purposes of temporary orders.
Yes, Your Honor. Thank you. Your Honor, I have no further questions for this witness.
Mr. Tracton, your witness.
Ma'am, you said you don't have any master's degrees. Is that accurate?
Correct.
Okay. And you taught school. What did you teach?
I taught art for elementary school.
And you said you've applied to numerous school districts. Is that correct?
Correct.
And that's for a job in what?
Any position for teaching
And how did you apply?
online?
And what did you do online to apply?
Well, for every school district has their own process. First, you have to go online. You have to fill out everything. You have to send them all your credentials. You have to do fingerprinting. You have to have your license updated. And you have to send all of that to each school district. And then they look through that, and then whatever school's interested in you, they contact you. And then if you're interested in that school, you go for an interview, and then if they like you, they hire you. If they don't, they don't.
Okay. And when you made your applications, what did you do to follow up to see the status of your applications?
I constantly go check on it, and I have refreshed it several times.
Okay. You say you checked to see if they contacted you. Is that what you're saying?
No. I check on my information. I go back and I try to refresh everything just in case if somehow maybe it'll pop up more for them or they'll see it more. I don't know how the process works. I don't see anything that they do.
Okay. And in regards to making telephone calls to the schools and school districts, did you make any to inquire on the phone?
First of all, that's not what you do, but for the people that I did know, I did contact them, yes.
Okay, but as a follow-up, other than just resumes online with the rest of the herd, as we'll call it, did you make any other efforts? Did you go to the schools? What other efforts did you make to try to get a teaching job like other people do?
I had one offer, which I contacted the school, and I knew that school. That was the school that I taught at before. I contacted some of the people that I knew from the past, and I was offered a job, but I did not get the job because Sean had our marriage license and he refused to give it to me. And my documents from my teaching were all under my maiden name, and they would not refresh anything of my license because my last name is different now, and they requested my marriage license, and Sean did not give me that. And by the time I corrected that, they had already hired somebody.
In regards to the job you were offered, when was that?
It was towards maybe the end of school year, this past school year.
So that would have been when, in 2020?
We're in April, like maybe April of last year.
In the middle of the
I
COVID?
don't remember. Yes, it was in the middle of the pandemic.
And were they offering you a position for immediate employment or for the August time period?
It was immediate. When I could not come up with my documentation, they filled it up within days for someone else. They needed someone immediately.
And what did you do to contact? You said that it's your position that your husband had possession of your marriage license.
Yes.
How did you know he had it?
Because I know he took it.
How do you know that?
Because he took all the documents.
Are you saying that he had already left the house at that point?
Yes.
But he didn't move until June of 2020. You said this happened before the school year ended.
Okay, then maybe I'm telling you the wrong date, but I have text messages where I send him text messages asking him for the documentation.
Sustained after, maybe I was wrong on the date.
I'm sorry, I probably am wrong with the dates. Everything blends in for me in my head for the past year and a half. But I could go back and retract the date for you.
Not responsive.
Hold on, Ms. Manu, wait for the next question.
Ma'am, what do you're familiar with the home you live in as to its value?
Approximately, yes.
What do you think it's worth?
Your Honor, I'm object to relevance. We've agreed to have the home appraised.
Your Honor, the value has been an issue.
I know, I understand. Overruled. You may answer that, ma'am, if you have an opinion.
From what I've talked to realtors, people that I know, and from what I've seen online.
Responsive, Your Honor.
Your Honor, I think she
Sustained.
the basis of her opinion.
Your
Not
Honor,
saying what they
Well,
said. She's given the
He's not
basis.
he's not asking, hold on. He didn't ask her for the basis for her opinion. He just asked her if she had an opinion as to the value of the home. So sustained is the
I'm not
non-responsive.
sure. I'm not sure.
do you think, you heard how much that Sean thought it was worth, which was 1.5 million. Do you have an opinion if it's worth more than that or less than that? Or
Probably
equal?
more. Probably more.
And Your Honor, I'm going to object. I believe that misstates Mr. Manu's prior testimony. I believe he gave a big range on that.
The court recalls the testimony. So sustained.
Ms. Minogue, you said you thought it was worth more than $1.5 million or the value that Sean said. Is that worth by the hundreds of thousands of dollars more or just a small amount more?
Your Honor, I'm going to object. She's calling for speculation. She's not qualified to give it beyond this, her opinion.
Overruled. If she has an opinion.
Go ahead.
Probably a couple of 100,000 more or 300. I don't know exactly. I would have to go find out how much each per square foot in the neighborhood in the area for that kind of house is, and then figure it out based upon that.
And do you feel an appraisal of the house will give you a fair value for that house?
I'm hoping.
I'm not talking about somebody buying it. I'm talking about the appraisal itself would prove beneficial for you to be comfortable with the value of the home.
I don't know. I have to see it before I could tell you that. I don't know.
Are you aware of any sources of funds, whether it's in an account that your husband has or an account that you have that has the money to do the appraisal that you're asking for the business?
I don't have it. I don't know what my husband has.
When you were talking about you took money from the safe, the remaining 20,000 is what your testimony was. You also testified that Mr. Mary had taken money in and out of the safe in the past, correct?
Correct.
Okay, now he's done that for years to the money in that safe, isn't that correct?
Some of it, yeah.
Okay, and the money that got into the safe, Mr. Manui put it in there too, correct?
Yeah, he was handling the money.
Okay, so when he says that the money was, I'll rephrase the question. When you were testifying about him removing money from the safe, what did you see him do? And between the January of 2020 and June of 2020? How much money did you see him remove?
A lot. I don't know exactly. I couldn't give you an exact figure, but it was a lot.
Okay, my question to you is, what did you see?
What do you mean? What did I see? I'm not understanding the question.
I'll rephrase it for you. On January 1st, 2020, are you aware of any additional money between January 1st, 2020 and June of 2020, more money being added to the amount in the safe?
Being added, no.
Okay. How many times did you see Mr. Manui take money from the safe from the same period? I'm talking the January to June 2020.
I didn't keep up with how many times he went and took it. I just knew that I periodically would check the money because initially he was hiding all of it from me and then he put it in the safe.
Okay. And the amount of money that you saw in the safe between January 1st, 2020 and June of 2020, what was that amount that you saw, that you checked on in the safe?
Can you repeat the question again?
Yes, between January 1st, 2020 and June of 2020, you've testified that you checked the money in the safe, correct?
Correct.
How much money was in the safe at its highest point on that period?
Maybe 200,000. I don't know.
When you say 200,000, did you count it?
roughly,
You roughly counted it?
yes,
How do you roughly count the money?
because it was in bundles.
I'm sorry, it was in what?
It was in bundles,
Bundles? And did you count the bundles?
correct.
And when did you see the money go down?
When did I see it? I have pictures of it. I can tell you the exact date, but I don't remember dates. But I do have pictures of this. I took the pictures of the safe as they went down.
Okay, and when was it you were taking pictures of the money in the safe?
When it was going down. I don't remember the date to give you.
Was it in 2018?
It was before he left.
Objection, Your Honor, asked and answered.
Please.
Sustain.
Was it between January 20th, 2020 and June of 2020?
Yes,
And was it all at once or in diminishing amounts?
diminishing amounts.
Okay, and you said that the Jeep, the yellow Jeep was purchased how?
He used part of that money to purchase, to pay for the, I guess, the down payment or whatever he did. I don't know how he did it, but he told me he paid for the Jeep with that money.
Okay, and were you aware that the Jeep was financed?
I was, but he did pay cash for it too, part of it.
Okay, your testimony before is he bought the Jeep with cash.
No, I didn't specifically say that he made the down payment. How much he paid out of it, I don't know, because I was never part of the purchasing of the Jeep. He did that because I did not want him to do it, so he did it by himself. I don't know what he did. But he told me he paid for the Jeep out of that money. How much he paid for it, I don't know.
And so the truth of the matter is you have no idea how much came out of the safe for the Jeep, correct?
Correct.
Okay, and then the actual reality is you don't know when the Jeep got paid for. Is that correct?
You mean paid off?
Yes.
Further down, I don't know how many months it took. No, he did not. At that point, we were not communicating.
response over- After, I don't know,
Be careful, don't go down his track.
what level schools did you apply to for the, and what position did you apply for when you were applying to schools?
Objection, I think that's been asked and answered, Your Honor.
I don't think it was specific.
The school districts I heard, but the actual position I haven't heard. So overall for that portion of the question.
Okay, but I did think she testified for any position available, Judge, but.
Okay, I didn't hear that. But
You apply to a district. You don't apply for a specific position. You apply to the district, and whatever they feel you
Objection,
qualify
non-responsive, Your Honor.
for based upon your credentials, then they email you.
You worked in the automobile business as a finance manager. What are your qualifications to be a finance manager?
My qualifications, not a whole lot.
How did you get a position as a finance manager as a dealership?
How did I? I was bold. I was young.
Your Honor,
what
get
other-
object to relevant.
What other types?
Objection relevant, Your Honor.
overruled. Overruled.
Thank you.
What other?
I recall this
position-
testimony before that she'd been out of the line of work for 10 years. Someone made her an offer, and then when they actually talked to her about how long she'd been out of the field, that things had changed a lot. I recall a lot of that testimony, but it's relevant. So the objection's overruled. Mr. Tracton, you may continue.
What other positions other than a finance manager and a teacher did you apply for?
I have been on LinkedIn constantly.
Objection not responsive, Your Honor.
Sustain.
What positions have you applied for other than a school district position and a dealer working as a finance manager position?
I have applied for positions that I could utilize my teaching experience other than a teacher, maybe some sort of tutoring, maybe during COVID, I did a lot of, tried to get a position as a homeschool teacher.
You were aware during COVID that there was a very large demand because they couldn't find people who were able to teach the children in these families because of the
Your Honor, I'm
COVID.
gonna object. That question makes her assume some almost expert facts.
All right,
I'll rephrase it.
objection is sustained. Facts, not in evidence.
Ma'am, your son provided you with 2 opportunities for jobs that you did not apply for. Is that
I'm
correct?
going to object to hearsay of what her son did or did not do.
Your Honor, she'll know that answer without having to do hearsay. She won't need
Do
hearsay.
what, Mr. Trachtenberg?
I was asking her if her son did that for her, not to repeat what he said.
All right, the objection is sustained.
Did any of your family members try to help you get a job?
My family members are not at a place where they can help me with those jobs.
Objection non-responsive, Your Honor.
No,
Sustained.
my son, yes.
Okay, what types of jobs was it your son tried to help you with?
He offered for me to apply to the company that he works for as an assembly worker.
And did you make that application?
I did not. It's in Willis, Texas.
Objection non-responsive.
After I did not sustain.
Does your son work at that same location?
Yes, he does.
And where does your son presently reside?
College Station.
And the place that he resides, is there room in the house that he lives in for you to live there too?
I cannot live there. My daughter's coming back for school. I
Yeah.
can't leave her here.
Objection non-responsive, Your Honor.
Objection relevant, Your Honor.
The home your son's living in is one, the
Sustained.
home. No,
Objection.
Your Honor, a question I have is not related to the statement you're about to hear. If I can have a little room. Okay. Ma'am, who owns the home that your son is in?
We do.
Who's we?
Sean and I.
Okay, and since you own it, is it paid for?
Yes, it is.
So it's not a stranger's home, it's not your son's home, it's your home that you could live in, is that correct?
I'm sorry.
It's your own home that you could stay in, isn't that correct?
I would have to kick someone out of there for me to go stay there. Yes.
When you say kick someone out, is that a tenant or is that your son?
Well, my son's there right now. My daughter's there. My son's girlfriend's there, and my son's friend's there. There's 4 people living there.
Okay. In regards to you being able to live in that house, since you own it, accommodations could be made for you to reside there and have a job so that you'd have a positive cash flow and assist yourself in making payments on your debts. Wouldn't that be correct? Okay. And how many jobs did your son help try to make a recommendation for you to?
The one that I just mentioned in Willis,
Any others?
Texas.
Were there any others?
We've brainstormed ideas, but nothing in particular, no.
And do you know how much the Willis, Texas job was paying?
No, I just can't drive to Willis with my car. I can't afford to replace my
Objection
tires.
non-responsive. Questions, do you know what it
I'm
is?
sorry.
Sustained after no.
Okay, you can't afford to replace the tires on what? How old's your car?
It's about maybe 3 years old.
And it's the Mercedes motor vehicle, correct?
Correct.
It's under warranty itself, so you don't have to worry about it. Is that correct?
Replacing tires is not under warranty, and those tires wear out every 3-4 months if I drive that far on it.
The fact that you've only been offered one job opportunity, you didn't take even that one because there's no others?
I'm sorry, Your Honor, I'm not sure what the question was. It was a statement of something she didn't do.
Sustained. If you can rephrase it, Mr. Tracton.
Thank you, Your Honor. You were only offered one job out of all the positions you applied for, but you chose not to take that one job. Is that correct?
I was never offered a job. I don't know what
And
you're
they're
referring
gone.
to.
So when I asked you about your son said he could get you the job, then you didn't even take it farther than just him saying that to you.
He did not offer that job to me. He just said there was an opening on an assembly line.
If you had that assembly line job available to you in Houston, would you take it?
If I could make a living off of it, of course I would take it.
How much do you need to make a living?
Your Honor, I'm going to object. She submitted her financial information sheet. It's in record. This is temporary orders.
But Your Honor, she's putting a line in the sand about what she'd apply for.
No,
Overruled. You may answer that, ma'am.
I need to make at least 4,000 is what I've been paying bills for, which does not include anything from my personal self. At some point, I need to live as a human being too. I can't just pay bills and live. I don't do anything for my kids because I don't have money. I need to have some money to do that too. I'm human. I can't live off of $2,000. I understand I can get a job at Target, Walmart, but I can't survive off of $2,000. I've had offers for $2,000, but I can't survive off of that.
So if you would turn down $2,000 if it was offered just to even help pay the bills with?
No, at this point, I don't have the offer, but I haven't been searching for those jobs. I've been trying to search for something that requires my qualifications, something that would pay me enough that I can live off of.
When this divorce is all over, there'll be enough money for you to be able to live off of that, the funds from all the properties. You
objection, Your Honor.
understand that?
Objection, Your Honor. Assumes facts and not in evidence. It's causing her to speculate, and I'm not sure it's even relevant to what we're doing right now.
All right, I'm going to sustain its relevance.
You have things that you could sell if you needed to get financial help for yourself, correct?
Other than my own personal stuff, no, I don't have anything that I can sell.
Well, your personal stuff includes a rather large amount of jewelry, correct?
Okay, that jewelry was all gifts to me.
Objection, unresponsive, Your Honor.
Sustain.
In order to survive and pay your bills and take care of the things you want, you have physical possession of property. There's in dispute at the moment as to its characterization, but you have something you could sell that would help you survive every day and pay all your bills, correct?
Correct.
Okay. And you have a very large shoe collection, don't you?
You know what, Mr. Tracton, you can have my shoes. You can have all the shoes. You're very obsessed with my shoes. Both of y'all can split that. Gift from me.
Objection, Your Honor, not responsive.
I'm sorry.
Sustain.
Are you aware that the state of Texas has trying to collect money from the business that your husband and you own shares of stock of? Taxes?
I own shares of?
Are you aware?
I'm sorry, I didn't hear
of-
that response. What did you say, Ms. Minot?
That I own
Minui?
shares of?
Your Honor, I think she might be confused as to the way Mr. Tracton characterized the ownership of the asset. So I think she knows the answer.
I thought she was answering it, Mr. Tracton, and I didn't hear it, but she was asking for clarification. So if you can please rephrase your question for her.
I shall, Your Honor. Ma'am, the business that you and your husband have owned for the last 20 years are you aware that there's a very large tax obligation the state of Texas wants from the business?
Correct.
Okay, and did your husband offer you the business if you would just take that loan? Or excuse me,
Objection, Your Honor, calls for settlement negotiations.
Sustained.
Ma'am, do you have an opinion if that business is worth more than the tax lien that's against it?
Your Honor, I'm going to object. We're here for the very purpose of getting an expert opinion. She's not even qualified to guess what that would be.
Well,
I'm
it's
asking-
overruled. She has an opinion. She can give it. Do you have an opinion, ma'am, as to the value of the company?
I do not, sir.
Do you have an opinion if it's worth more than $1.4 million?
I do not know.
Objection, Your Honor, ask and answer.
Overruled.
Do you believe your children should continue their college educations at this time?
Absolutely.
And based on that, do you have an idea where the money's going to come from so they can?
I believe we have enough assets that we could pay for that.
You use the word assets. I'm asking about cash money. Do you know where cash money is to keep writing checks to their schools?
I think we've established that there's no cash money at this point.
So how would you propose that the bills for your children that you just said you want them to stay in college, where would that money come from?
Liquidated assets? I don't know. I don't know what you're asking me.
Your Honor, I'm going to object that we're getting outside the scope of this temporary orders hearing. No one's put any pleadings or motions into how the kids' college is going to be paid.
The FIS
So
is
it's a temporary spousal support, so the income and the expenses, I think, are relevant. So I know the college is not a mandatory expense of the community estate, but I'm going to allow it. You may continue, Mr. Tractor.
Thank you. Your Honor.
Objections overruled.
Ma'am, as I think I understood your answer, tell me if I'm not correct. You want your kids to stay in school and continue their education, not take a break because there's no money from you guys meaning your husband and you.
Correct. Their school's paid for till next December.
How would you know what's paid for from their schools? Are you involved in the payment of their bills?
I'm involved in every second of their life.
Okay, then what is it you know about how their school is paid for until December?
If my daughter charged it on American Express, which Sean just said he had paid for that American Express.
And that, you know, for the period of time that educational period is paid for? Do you know what, let me rephrase the question. The charges on the American Express card that is paid off each month by Sean, how do you know that the charge was payment for all her college expenses through December?
I'm not dumb. I know how much their tuition is and I see the charge. It was their full semester's payment.
And are you aware which semesters they were?
Of course I do.
Please. How do you know?
I helped her enroll in her classes.
And that would be for which semester? Is she going summer semester?
I'm
Your
sorry?
daughter- Is your daughter going to summer school, summertime during the, school?
Yes, she's planning on it.
Wouldn't she pay for that before she's going to pay for her fall semester?
Obviously, you don't know how that works either. She's paid for both. Enrollment already started.
What were damages to the house from the freeze?
There was damages to the water well. There was damage to the to the propane tank, to the line. There was everything else I managed on my own.
What does that mean?
What does that mean? That means that I took care of it every day as it came up so that it wouldn't become a costly problem. I
Did you
stayed in
have
the
to hire-
house without electricity and water to make sure the house was taken care of.
Did you hire contractors to make repairs?
Some of them, yes. Some of them, I asked people that I knew to come help me fix them, and I helped them financially.
You said you borrowed money from people. Who are the people you borrowed money from?
My family,
Who in your family?
my brother,
And when was that?
it was maybe about a month ago,
How much did you borrow?
3,000.
You had testified you cashed the $4,000 monthly spousal maintenance checks that your husband was sending to you, correct?
Correct.
How did you make the payments on the debts that you had on the checks from cash to the creditor?
What was the question again? I didn't understand that.
You were using cash. You were cashing the checks, the $4,000 monthly checks, and converting them into cash, correct?
Correct.
From the cash that you converted
Mhm.
to the $4,000, what bills were you paying with cash?
I paid the propane because they come to the house and I paid them. I've paid some of it. I believe I deposited because I wrote checks for some of the bills, and some of them I made payments at the grocery stores.
Okay. Propane is filled how often?
I've been filling it every month.
Is that what was done when prior to you changing it to month? Has that always been that way?
Last propane bill. She has not paid.
All I can tell you is I've been paying it monthly. I don't know what you're asking me for.
Your Honor, can I object to a line of questioning, relevance line of questioning on the frequency of this?
You know how long the litigation's been taking place on Glamour Girls? The Glamour,
Check for Your Honor, relevance. I have this one document on the girls.
I'm asking what she knows, Your Honor.
Your Honor, it's
I'm
remarkable.
sorry.
Judge, I think I'm objecting to this, and I don't think it's relevant. But I think it's remarkably unfair for them on one hand to withhold every single piece of information on that.
I'm going to
company.
sustain the objection to relevance as to how long they've been in litigation. I know that sounds like $1.4 million judgment.
Ma'am, do you know who the lawyers are that are working for the business to try to save it for you guys?
Absolutely, yes.
Who is it?
It's Tridico and I forgot his name. The partner.
Have you had communication regarding the business with them?
Regarding the business, no, I had communication.
That's a non-responsive after that. No, Your Honor.
Sustain.
So it's solely on your husband to try to save the business and work with the lawyers. Is that a correct statement?
Can you repeat that?
Yes, by you not being involved in working with the lawyers for the business, your husband has been the only person that is involved in trying to save the business that sustained you guys for 20 years.
Correct, that's how he wanted it.
Do you think the particular business that you've been in for 20 years is a bad business to be in morally?
I never agreed to it from day one. We almost got a divorce when he started it.
Has it kept you in a very good lifestyle in the past years?
Financially, yes. Emotionally, no.
Is that why you didn't go there and work with them or try to be involved in the business?
Are you asking me if I wanted to be a dancer? Is that what you're asking me? Okay.
No, does your husband dance in the business?
Object is relevant, Sean.
I was just asking about the other occupations in the business. Thank
Well, if
you.
we want to
I
talk
have-
about your
I have-
husband's other occupations, we can get into it.
I have offered to do paperwork for him in the past, but he did not take that offer. But I'm not working inside the club, no. I refuse that at any expense.
Your American Express card that is in your name also has both your children on it. Is that correct?
Correct?
And you had said your daughter charges her tuition on it, correct?
Correct.
If that card isn't paid off every single month, what happens?
It's delinquent.
And how is it, what happens to the money that your children are charging on it? The charges for your children. I'm going to rephrase the question. Do you receive that bill each month?
Sean picks up the mail. I don't see the mail.
You were saying that you thought that, I'll abstract that question. Your children have more than one vehicle each, is that accurate?
My son does.
Okay, are you going to be telling your son which vehicle he gets to see?
Your Honor, relevance.
Sustained.
Do you want your son's vehicle, either vehicle of his, one or both, sold?
Objection, she's already testified to what vehicles should be kept.
Your Honor, they've only talked
Ooh.
about 14 vehicles. Thank you, Your Honor. Should your son's extra vehicle be sold?
No.
You're aware of how important the car collection is to Sean, aren't you?
Yes.
And you're saying sell them because that would hurt him, wouldn't it?
Absolutely not.
You don't think he'd feel bad selling those cars?
Objection, Your Honor, relevance. Objection, Your Honor, relevance.
Sustained. Sustained.
How long will it take for you to prepare the house to be sold?
I'm not sure.
How long, do you have an idea where you might move?
No, I don't. I don't have any money. I don't have anything. So it's not-
Objection non-responsive, Your Honor.
Sustained after, I don't know.
You recall in November, we talked about selling the house back then. Do you remember that?
Correct.
So you've known about the house being sold or needing to move since
Relevance at this,
November, isn't that true?
Your Honor, I'm going to object to relevance at this point. We've agreed to put the house on the market.
Your Honor, my
Overruled.
question is going to what, thank you, Your Honor. You've been aware you'd be having to move at some point, weren't you?
Correct.
And you have not even investigated where to move, correct?
I would do that if any piece of
Objection non-responsive.
lasted longer than 3 days.
Sustained.
Today is gone tomorrow.
Sustained.
The tax returns for you personally are located at the house. Are you aware of that? yours and Sean's tax returns from 2017 and 2018.
Now, Sean took all the bucket of tax returns and everything. There's no paperwork in the house anymore.
When Sean came to work on the motor vehicles per the temporary orders agreement, you came out and were telling him he shouldn't be there, correct?
Absolutely wrong.
Were you present while he was working on the motor vehicles?
He came on a different date. He did not come on his date. And I asked him if he would text me if he was going to come on a day so I would be aware and I would be home. And he got upset that I said that. I said, I'm not telling you don't come. I'm just asking a courtesy text message. Pam, I want to come start my cars today.
Your son was present with him at the time he was there?
Correct.
And your son witnessed the,
Your
how
Honor,
you were-
relevance on this?
I'll rephrase the question, Your Honor.
Thank you.
You were yelling and screaming at Sean, weren't you?
Relevance, Your Honor?
He was too.
Hold on. What's the relevance of this, Mr. Tracton?
That he's not been able to be working on his cars, Your Honor, and the maintenance of those.
No pleadings. There's been nothing to indicate that it's been done.
Objection sustained.
What needs to be repaired in the house to make it sellable?
For one thing, the landscaping, which I also asked Sean to help me financially so I can take.
Objection non-responsive, Your Honor.
Sustained. After landscaping.
What needs to be done with the house other than landscaping to get it ready?
Not a whole lot of anything, nothing major.
Okay, so if it's nothing major, could it all be done and scheduled to be completed in a week?
No,
No?
no.
Okay, what will take longer than a week to complete?
I'm not sure. I have not evaluated all these questions that you're asking me. I have not gone through the house to see exactly what needs to be done. If it needs to be painted, I know ceiling needs to be fixed. And his museum where he took everything out of it, there's a broken glass in there that needs to be fixed. I have not evaluated everything to give you an exact date of how many hours or how many days it would take to fix things.
Do you have people that can make those repairs that you can call immediately?
I don't know. Everybody's so busy right now. My parents are remodeling. They can't get anybody to come to their house to remodel for them. It's been 3-4 weeks they're waiting. So I don't know.
Objection non-responsive, Your Honor.
Sustained.
Have you gotten estimates for any of these repairs that you're referring to that need to be done in the house?
Not yet.
Have you checked on places to store your furniture and furnishings if you aren't able to move it to a new residence?
I don't know what it is that I'm moving, so how can I look for storage?
How big's the house you live in?
So does that mean I take everything inside the house?
Your Honor, objection non-responsive. Would you tell him how?
Sustained. How big is the house? I think it's 7,800 square feet from what I remember from y'all's last hearing, somewhere around there.
Your Honor,
Yes.
but I will object to one of the questions. I do think we're getting outside the scope of what we're attempting to do here today, which is go for expert fees and a little temporary support. We've agreed to sell the house. A lot of these questions that are coming up are questions for a realtor, frankly. Questions that might follow after an appraisal.
Well, I think what I'd like to do, Mr. Tracton, I understand your questions, but I think I'd like for you and Mr. Broussard to try to work some of those out before we're trying those issues, because it may be that y'all can narrow those issues down and it might be a more efficient way for everybody to do it. So I am based on the fact that this case is not going to get resolved as quickly as I had originally hoped, I am inclined to sell a home that's this big, and I am inclined to do that on a pretty quick time schedule because I can't imagine the overhead cost, even though there's no mortgage on 4 acres and a nearly 8,000 square foot home. I mean, that's costing these parties a lot of money. And originally, I thought there might be a pretty quick, since the business was, I thought was about to be closed, that we might have enough real estate where mom could stay in one house and other real estate given to dad. But with the amount of time this case is taking, and I'm not saying that it's not because the lawyers are working it diligently from what I can tell. But the fact is, and I think I told y'all this last time y'all had a hearing, there's a lot of uncertainty in this case because of the judgment that the state has against one of the largest assets probably in the company, which was the business.
And Your Honor,
So,
Bill, I don't think it's.
I just don't think it makes sense to continue to carry the upkeep of this large home. So it does need to be sold, and I do think it needs to be sold or on the market pretty quickly. But Mr. Tracton, as far as going into what does she need to put in storage, I mean, I think those are arguments for another day if I need to get into that. But I'd rather focus on getting these lawyers paid and then getting whatever I need as far as experts to get this case completed. Because I understand he may take a position that the business is worth nothing with the judgment that's against it. But if I have, the other side doesn't think that's accurate, then they're entitled to have an expert appraise that business and determine whether or not it is in fact a negative asset. And if it's a negative asset, then the court can always factor in the attorney's fees and experts' fees that were incurred in order to get a report that says we have a negative estate. And that's something I can factor into a property division. But the fact is, I've got to have that business appraised when there's a disagreement over whether or not the business has a value. And so I really want to focus on that for the rest of our hearing so that I can get this case moving. All right, Mr. Tracton, so if you can go ahead and move off of the storage stuff and what needs to be done in the house, because I'm going to let y'all try to work that out.
Ma'am, when you attended job fairs, what kind of businesses were the job fairs for?
Mainly teaching.
Okay. What was the last time you did a job fair? When was it?
It was, what month are we in?
May I respond?
February, I believe. February.
Okay. And other than teaching, you haven't attended any other job fairs?
No.
You keep a log or any kind of documents that would show when you've applied for jobs, where you've applied for jobs, and how you followed up on those jobs?
Some of them, yeah. For a while I was, but after a while I lost track. It was too many.
I'm going to pass the witness, Your Honor.
Just a couple of questions. And I think.
First order.
Yes, Ms. Minot, Mr. Tracton was asking you about talking with the company employees. Do you remember that line of questioning? I'm sorry, not the company employees, the company attorneys. Remember that line of questioning?
Yes.
And he asked you if you talked to them about the lawsuits in the company, and you said no. Remember that?
Correct.
What did those lawyers talk to you about, ma'am?
Hearsay, Your Honor.
Your Honor, he opened the door for this.
I didn't.
Abstain.
Thank you, Your Honor.
Ma'am, have you talked yourself to the company lawyers about issues in this divorce?
Not about issues about the divorce, but I have talked.
Objection not responsive after not.
What did you talk to the company lawyers about?
I spoke to them when Sean had his accident.
Okay.
Objection as non-responsive, Your Honor.
Okay.
Overruled.
Judge, I have no further questions for the witness.
Mr. Tracton, anything further from this witness?
Not at this time, no, Your Honor.
All right. Any other witnesses you'd like to call on your motion, Mr. Broussard?
None on my side, Your Honor.
Mr. Tracton, any witnesses you'd like to call?
I'd like to call on Mr. Minowie, please.
Yes.
You may
Just-
proceed.
I'm sorry, sir. Oh, okay.
I said you may proceed.
I didn't hear that, all that. Thank you. Don't, no. Sean, I'm trying to figure where I wrote it.
Your Honor, can I talk? No,
No, please. It's a question and answer
I know.
format.
I figured while you're looking for paperwork, I can tell them something.
In regards to, I actually had the questions written down. Give me a second, Your Honor, because I wrote them and I'm turning pages.
You may.
Sean, in regards to making any repairs to get the property ready for sale, between yourself and your wife, which of you would be better knowledgeable or able to get that accomplished quicker?
Myself, of course. I've always done it.
Have you had experiences in getting properties ready for sale or otherwise?
2 phone calls.
No, have you had?
Yes.
Okay. Do you have contractors that you're familiar with and would be able to take on and do whatever repairs are necessary to get this done promptly?
Yes. A phone
Okay.
call away.
In regards to the 2 lots that the judge had talked about during after you had testified originally,
Mhm.
are they would you agree or disagree with the judge that those, let me rephrase that. Would you agree or disagree that those should be the ones that are immediately being able to sell faster or not faster than anything else you have?
Offered that to Pam a month and a half
Objection,
ago.
non-responsive.
Yes.
Thank you. The vehicle, you heard your wife speak of $200,000 being in the household safe between January of 2020 and June of 2020. Did you remove the money from the safe that you said is missing?
First of all, it was not $200,000, but I did remove
I'm going to
some.
object to non-responsive. I'm going to object to this line of questioning. Obviously, these parties are both blaming each other for something we're not going to solve today.
Overruled. You may answer that, sir.
You said you could answer.
Sir, you may answer that.
I'm sorry. I thought
You
you
said it wasn't 200,000, and
It
what was
was
the rest
not.
of your answer?
It was about $25,000 more than 130. It was 155 or so. My dad had passed away. I used some of that money. He had given me that money to use it for his funeral. So I paid for the funeral.
Hold on. There's an objection. There was an objection non-responsive by Mr. Broussard. It'll be sustained at this time.
Yeah.
All right, Mr. Track, the next question.
No. When your wife testified, she saw you removing money from the safe. You heard that?
I did hear that.
What was that money that you were removing from the safe used for?
I used some of it to replace the carpet at the club, and I had already paid for my dad's funeral out of that money.
And when all that was said and done, do you know what was left in the safe?
130.
And was there any money left in the safe when you said the 130 was gone?
No.
And before you saw the 130 missing, was there a limited amount before that 130 went missing? In other words, was there some other number in there that from when you last saw it,
No,
130 in it?
no.
How often were you in that safe to know what amount of money was in there?
Once every couple of weeks, 3 weeks.
Okay.
I didn't go in there for money. I just went in there for other.
Objection, not responsive.
Sustained.
Accident. Briefly, I can tell you.
Well, I'm thinking. The the your wife said something about an accident. What do you know what she was referring to?
And I'm object to relevance. They're talking about something years ago, Judge.
I'm not sure how it's relevant. I know she testified about it, but Mr. Tracton, y'all know more about this accident than I do, I'm sure. I don't know how it's relevant. So can you tie it in for me, how it's relevant?
I was just going to use it as an explanation of timeline, Your Honor. Just as Mr. Broussard had said, it's ages ago, not present.
And again, I'll just
Okay.
reiterate my objection on.
Sustained.
So answered or not?
No. Just trying to find what I do with the damn question I had.
These commercial cars and houses.
I don't know. Your Honor,
Yes, sir.
oh, let me ask a question. How much money have you paid to Mr. Broussard? Oops, I'm asking the wrong person, the wrong question, aren't I? Sorry about that. Wrong witness.
Well, Mike, to be fair, y'all
I'm
weren't
good.
pay some money directly to us, so in that regard.
How much, ma'am, do you have, wrong person again, didn't it? I'm going to pass the witness.
Thank you. Your Honor, I have one line of question and I'll be done. Mr. Minot, before the lunch break, you stated that your wife had admitted to taking $100,000 and had $130,000 and had told you what she did with it and that you thought or she thought that was a good call. You remember that?
I'm Scott. I'm sorry. I had a hard time hearing my clients.
Okay.
having a little-
Before the lunch, I'll let him get some water.
Just
Yes.
getting some water.
All right, what was the question?
Before our break for lunch, you were under oath and you testified that Ms. Minot had admitted to taking $130,000 out of the safe, had told you what she did with it and why she thought it was a good cause. Do you remember that testimony?
I never said that.
You did not say that.
That is not what I said.
So if the record reflects that you said she admitted taking it,
She admitted taking it, but I didn't say what she used it for and all the extras that you just added.
when
That's
did
not what I said.
she admit taking it? Because the record will reflect what you said. So when did she admit taking it?
When did she admit? I don't know,
Yes.
a few months back.
Okay. A few months back, November, October, September, help me out.
January. maybe.
And how did she
February.
admit to you by text?
No,
Okay.
verbal.
Verbal, okay. Were you over at the house when she verbally admitted it to you?
I don't remember.
Oh,
Yeah, I was at the house actually. Actually, that was the day that I went to start the cars.
mhm.
That's when she blew up on me.
Okay, so all right, very good. So your son was there, correct?
He was upstairs in the shower.
Oh, he didn't hear that. Darn it. Okay, no further questions.
What are you trying to get to?
Oh, sir, I've proven my point with you. No further questions.
Objection to
Mr.
sidebar, Your Honor.
Mr. Broussard, Mr. Broussard. No, Mr. Trackton, any redirect?
I want you to ask me what happened that day when I went to start the car.
Mr. Sean, you heard the questions that I asked your wife about the event of you going to your home to work on your cars. Do you remember that?
I do remember that.
Can you tell the court what happened that day between you and and Pam?
Okay. All right, Your Honor, you had originally authorized for me to go every other Saturday. Okay, wait, he just,
No, you don't.
Objection, non-responsive, Your Honor.
Overruled. You may continue, sir.
Your Honor, when we had our last court hearing, you authorized for me to go to start my cars because they need attention and maintenance every other week. I was supposed to go there on a Saturday, every other Saturday or something in that nature, correct? You remember that?
He's got to answer questions. Objection.
So right after our hearing, she had COVID. She was at the house for 2, 3, 4 weeks. I didn't want to go there because of the COVID. Okay. One Saturday, I went to start the cars. That day was the day that was the 4th time that me and Pam, I offered Pam, let's try to settle this instead of going through this.
I'm gonna object. He's talking about settlement negotiations.
Wait, I'm
No,
not
you
talking.
can't argue.
Hold on. We can't get into settlement negotiations. That's not appropriate for the judge to
wasn't-
hear. So
Your Honor, I was not going there. I was not going there. I was just going to tell you what happened that day. So that day I was going to have a meeting with Pam that day. And in the meantime, I was going to start the cars. I was on that Saturday. That day after our meeting didn't go anywhere, started raining. My son was in a class that day. He was supposed to be helping me. It started raining. I ended up leaving. After his class, he ended up calling me saying, hey, my class finished. Are you still at the house? And no, it started raining. How about if we meet tomorrow? Are you doing anything tomorrow? Which was on a Sunday. He said, no, I can meet you at 10 o'clock in the morning. I said, fine. So I went to the house at 10 o'clock in the morning, grabbed the keys. I started starting the cars and she's giving me a dirty look. She comes up to me. She's like, what are you doing here? I said, I came here yesterday. Aryan wasn't here to help me. So he's here today. And it started raining. I'm trying to start the car. That place is 4 acres of land. She screamed from the top of her lungs where all the neighbors heard her.
Non-responsive,
hold on.
irrelevant.
Sustain. We're in a narrative at this point. Mr. Trackton, if you can keep it question and answer for me, please.
Okay. So I never went back.
Sean, is there a reason? Have you gone back to the house to work on the cars?
Never after that. Never after that day.
Wait, finish my question, please. After the date of the disagreement with your wife by her behavior, is there a reason you didn't go back to work on the cars?
I don't want to get cussed at every time I go there.
Has that happened in the past also?
All the times.
The question was asked of your wife about the tuition being paid. Do you recall her saying it was paid through December?
Wrong.
Objection, non-responsive. Do you
I
recall
heard that, yes.
Okay, and
How could it be
do
paid?
you make the payments or does she make the
I'll
payments?
make the payment.
Are you familiar with the payments that you've made as to when the semesters that were paid for your daughter?
Semester finishes at the end of May. It's paid till the end of May. I got to pay again in August for the next semester.
How do you usually know how much the semester costs are?
About $7,000.
How do you know about how much the semester costs are? Do you receive an invoice? Do you receive a bill?
No, the kids get an email from school. They let me know.
Do you get a copy of the email?
I don't.
And how do you learn from the children how much to pay?
They tell me how much the fee is, and they can't charge on their own American Express because they have a limit of 1,500, I believe. So I either give my American Express or they can charge on Pam's American Express, and I'll pay it.
And when you say Pam's, she's still the primary card holder, is that correct?
She is correct.
Okay, so when you're saying she, do you know whether or not you receive the American Express bills, is that correct?
Yes.
Do you review them each month for their accuracy?
80%.
Have you seen Pam make any payments for the children's semesters in this year?
All right, I'm going to object to line of questioning. I don't know why it's relevant at all, Greg.
Doesn't matter. I'll pay it anyway.
Thank you, Mr. Minow.
Look, I've got the testimony that he says it's paid through May. She says it's paid through next December, but it's not going to impact my decision one way or the other for what I'm doing. So I've heard enough on it.
And I'm going to pass the witness, Your Honor.
Your Honor, I have no further questions for.
Mr. Tracton, would you like to call another witness on your motion?
No, Your Honor. I'm resting on that part.
Okay, Mr. Broussard, any rebuttal?
No, Your Honor.
And I'm going to give each lawyer an opportunity to give me a brief closing as to what you'd like to see the court do. And Mr. Broussard, since it's your motion, you may go first.
Thank you, Your Honor. First of all, Your Honor, I would request that the court start with the liquidation of the cars. I think those are the most highly liquidated asset. We're all very aware of the market in Houston, whether it be Texas Direct, CarMax, or anything, and the way they do offer cars. I think that would be the quickest way to stop bleeding or meet the needs that we need here. I think I would ask the court to go through cars before we get into real property, as I do believe that real property is a preservation of an estate that is necessary that could help these parties once the divorce is finalized, whether they're building on one of these pieces of dirt or whether the market continues to go forward. I find, Your Honor, and just the testimony on this case, we want it done. We don't want to bleed money, but there's absolutely no voluntary disclosure of anything that would be necessary to do this. It's just outrageous, Judge. So we are asking for expert witness fees of $17,000 at this time, and I think we could sell one or two cars and get there. If the court's inclined to believe Mr. Minow's testimony that there's only $4,000, and I would be quite frank with you, Your Honor, I don't have any evidence, nor have I presented any evidence that there's any cash available. I question the veracity of that statement, but I don't have any evidence to support it. I would think if we've sold, 2 cars, that would probably be sufficient for my client to meet her needs on this $4,000 a month stipend. We have no problem selling the house, Your Honor, but we don't know how quick it's going to be. We've all sold houses. You get a realtor in there that tells you you got to do a million things that you weren't thinking you had to do. In my experience, while I know this house has to be sold, I don't think houses get on the market within 30 days, but I understand the house has to be sold. Now, I will tell you, Your Honor, I question the wisdom of selling it. I understand what it costs to fund it, but relative to what it's going to cost to move, store, and get something else, I question it. But nonetheless, we will do that, Judge. But what we are asking for, and Your Honor, I think you hinted it on this. I have been over backwards to wait to see what this entity, if any evidence come forward as to its value, whether voluntarily or through other avenues, and none of that's come. So the idea that Ms. Minow has somehow delayed is ridiculous. Ms. Minow has made substantial efforts to gain employment in a pandemic, and I think that that's obvious. And so with that, Your Honor, again, I would say, ask the court respectfully, start with the vehicles. We have a number of vehicles. We can still preserve vehicles and get what we need. If the court is not inclined to stop at the vehicles, I guess the real property would be next. And my understanding of that real property, Your Honor, I would just tell you that my understanding, because, and this is not evidence, I know it wasn't admitted in, but because we did handle the appraisals, I believe the property they were addressing was appraised as one unit, though it is two separate lots. So I just want to make Mr. Tracton aware of that. But the cost was done as one unit, or the value. And I'm sorry, Your Honor, I have nothing further.
Mr. Tracton?
Thank you, Your Honor. Liquidation of cars. I think it's clear Sean was saying that their value is not just the value that somebody will purchase it at. It's kind of like an art piece. If you appreciate it and you're looking at it, it has value to you that's above and beyond. He has testified these cars have a different level of importance. Not only that, but we've eliminated many cars from the list of cars that could be sold because the parties themselves have agreed not to sell those cars. That leaves just the few collectibles that that Sean is addressing that have been his babies. They have real property. They got a lot of real property. There's been testimony that there was 600,000 plus difference in the value. I say testimony. Mr. Broussard shared that there was a valuation difference from the belief that Mr. Inouye had as to the value of some of the properties that were already appraised and what their actual appraisal values came in at. There's been enough discussion to suggest that there's $150,000 worth of 2 or 1 lots that right up on the front were addressed as having that value. Just the plain lots, you don't have to do any work on them except cut them, the grass. And Mr. Inouye's already said that's a problem because they keep charging them out the gazoo for cutting the grass, and it'll get worse now as the season comes. So those properties are going to have expenses. You want to terminate something, Your Honor, that would, I mean, you want to cause something to be sold, I think they would be bringing a quickest and soonest values so they can be built upon, since as Sean had indicated, he is the person who deals with the real estate buying and selling, and they've obviously accumulated a fair amount of it. The remaining parts of real estate issues, these two are just investments. They're not living in them. They're not going to live in them. There's been no indication of that. These are just lots for the purposes of which, if we sell them, they serve their purpose. They made them money. As to the Ms. Inouye has made such little effort on her own to take care of her own bills and her own life that her efforts, she has set a floor for herself to how much money she wants to make, because her decision on bottom line was not for putting food on the table or paying her present bills, but she needs to survive and give her kids money. Well, this estate is a large enough estate. The marital home is large in its own right. The value of the property that's been talked about, and the testimony was from November, the club is only the entity. They don't own the building. They don't own the land. It's just rent. And there's no ownership. It's paid to somebody entirely different outside this relationship. So the only value of that club is the present value of somebody that's going to build it or make it, cause it to make it money after COVID. It's been a matter of the monies they've had to pump into it from PPP and everything else that's been testified to. Mr. Inouye is knowledgeable in the repairs that need to be made to the house. He's knowledgeable in the people who would be required to be brought to do those repairs. He would be the best person who would be able to take care of handling that. That would mean that his wife would have to expedite her schedule to find somewhere to reside at this point. And we're saying that we really need the house to be made ready. And I know that you've indicated Scott and I will work on that together. But I think that all these issues of experts and anybody else can be resolved by by Sean's suggestion. We have two properties, sell the properties, each take half the proceeds. Then they each pay for what they need to pay for. They're in, you know, they have control of enough money that belongs to the community to take care of it. The rest of it's still community money, but they at least have control of enough funds to do what they need to do for this case. And Your Honor, I think that, you know, Sean's going to be able to serve moving things faster than his wife will want to. And I can hear it's hard. It's not, she hasn't made any plan. She is stuck in just the idea that I'll just get my money every month and just keep living. We only learned today she's agreeable to selling the house. We're making baby steps. We're not making giant steps, Your Honor. This needs to be a giant step now. And we have an opportunity, and we're here for this today. We're asking that real estate be sold, and the logical pieces would be the lots that have been referred to. And Mr. Broussard is already identified that both parties know what those are. And with that, Your Honor, I'm done on my closing.
All right. Mr. Broussard, anything further from you?
No, Your Honor, except for I don't know that we have stated with any particularity what the lots are, and I don't want any confusion if you're so inclined to sell lots. So may I have?
Right. Well,
I'm sorry. Go ahead.
yeah. Go ahead.
If I have a moment, I'd like to make sure with Mr. Tracton that we're talking about the same lots. Okay. And so
Why don't y'all do that? I'm going to take a 5-minute break, and y'all talk about that while I'm gone. I will be back in 5 minutes with my ruling.
thank you, Judge.
Thank you, Judge.
Are we talking about the same? No.
He's off, we're on.
Okay. Mike, I think we're talking about Tankersley.
Yes.
Okay, and there's 2 lots.
I don't remember exactly because one is on China Grove, one is on Tankersley.
Hey,
One of them is
Sean, is that all in Treasure Island? Is Treasure Island
No, it's
separate?
not Treasure.
Treasure Island
No.
separate.
completely different.
Okay.
Yeah.
All right,
These are-
hold on.
No,
Secretary knows. Hold on.
There are 2 lots that are adjacent on Tankersley.
Oh, but one faces the
And
corner lots.
they were appraised together, totaling 74,000 if you sold both lots together. The other property in that subdivision is China Grove, and that was 85,000. So there's actually a total of 3 lots, 2 on Tankersley and 1 on China Grove.
Okay. We on the same page, Mike?
Oh, is that accurate?
that is correct.
So both in Treasure Island.
There's no Treasure Island. This is
That was my fault.
it's all right. It's called Sun Creek Ranch.
All right, so the Tankersley, Mike, are kind of corner lot. We had them appraised together. In the same subdivision, there's another one that's on China Grove.
Right.
Got it.
You got him. Now we're all together.
All right, I'm gonna put y'all on mute so you don't hear us, Mike. If you need anything, send me a text or something.
You got it. We're off mute and we're present, Your Honor.
Your Honor, are we on the record?
Not yet. We all ready to get back on?
Yes, Your Honor.
Yes, Your Honor.
All right. Court's back on the record. In the Manui matter, counsel, do you have something else you wanted to add?
I just wanted to clarify for the record that the parcels of land that have been addressed are actually 3 lots, Your Honor. 2 of them are attached or adjacent to each other. The 2 that are attached are considered Tankersley property between the parties. We understand that to be the Tankersley property. The 3rd property that is in the same subdivision but not contiguous to the 2 is on China Grove, Judge.
And the 2 lots that are together are a single value on the appraisal.
On the appraisal, they are appraised at a single value, yes.
It was Tankerley appraised for 150,000, or was it Tankerley and China Grove combined that was 150,000?
It's a combination, Your Honor.
Yeah, and it's a little bit more than that, but yes.
All right. And then I had a question because I didn't hear, I heard both lawyers say that, or I heard Mr. Tracton say he wasn't being paid. I know that's not before me today, but Mr. Broussard, I didn't hear anything about your fees. So are there outstanding fees for both lawyers at this time?
There will be, there are not at this time, Your Honor, and I did not bring it up because I did not plead it. I didn't plead additional attorney's fees at this time, Judge.
And Your
Honor, and the only reason I ask is I am going to sell, well, I am going to sell or order that we sell off an asset. And my thought is that those proceeds, I would like to see some of that go to the husband and the wife, but obviously until it's a final trial, I can't do that. That's something that the lawyers can agree to. But I'm not going to divide up property prior to having a final trial. But I can tell you that that money needs to go into one of the lawyers' IOLTA accounts. And I would use that to pay interim fees if I need to prior to a final trial, because last thing I want is this case to end up dragging on, get close to a final trial, and then have some lawyer jump off because they're not getting paid when there's sufficient assets in this estate to get the lawyers paid if that's an issue. But that's not going to be part of my ruling today. I'm just letting both lawyers know that because I heard testimony, at least, that Mr. Tracton was behind. It sounds to me a couple things before I give my ruling. It sounds to me like we are in a liquidity crunch from this estate standpoint. We've got a lot of real estate and we don't have a lot of cash, and we have cars and we have jewelry, it sounds like, but we have assets. We just don't have cash to get expenses paid and to get experts paid and to get lawyers paid. And so I do think we need to sell the Sun Creek Ranch properties. That's Tankerley and China Grove. Those can both be listed immediately. And I will let y'all try to work out the details on who the realtor is and the listing price on those. We have an appraisal, so that should give y'all a pretty good idea for what the properties are worth as far as a listing price. If we need to have a hearing on how to list it, then certainly we can do that. But my intent is it'll be listed for at or near what the appraised value was, so that it hopefully moves fairly quickly and it gets listed right away. The other issue I see with this case is it sounds to me like these fees, attorney's fees, and probably expert fees, are getting run up a little bit because there's not voluntary disclosure of documents. And I understand that if the entity is not a party to the suit, that there are things that lawyers can say, well, look, we don't have to produce these documents. The entity is not a party to the suit. The problem is if truly this is a negative entity, it's not worth anything, then I would think Mr. Manui would be forthcoming and saying, hey, look, you can have whatever document you need. This is a negative asset. And because the more we spend on attorney's fees to go get these documents, that eventually a lawyer is going to be able to get. It's not like that when a community estate owns an entity, both these lawyers know this, but this is more for the parties. The lawyers, once they do the right paperwork or have the right paperwork, those documents are going to be produced, and that's going to happen. So why spend a fortune in attorney's fees fighting the inevitable? It just makes sense to make those documents available so that the expert can look at it and go, golly, you know what? This is a negative estate, or this is a negative asset of the estate. And then it quits running up fees and it makes the case go quicker. And so I hope that I don't get a bunch of motions to quash on documents that are part of the community estate and need to be valued for purposes of determining how to divide up this estate, because I think that would really help speed things up, which would help both Mr. Manui and Mrs. Manui, because it would save their costs that they spend in attorney's fees and the costs that we're probably going to expend in expert fees. So that's just some words of advice from a judge. So for purposes of the ruling, those 2 lots in Sun Creek, or 3 lots in Sun Creek Ranch, will be listed immediately near the appraised value. I'm also going to order that husband pay $12,500 to wife's expert. That will be paid on the Bank of America credit card, which I show there's about $28,500 of credit available there. That's to be charged on that card on or before April the 30th of 2021 at 5 p.m. I know that's not exactly what the expert's wanting, but that should be sufficient for them to hopefully, if the documents are given up voluntarily, assess that the company and determine, whether or not it is an asset of the estate, or if it's a negative asset of the estate or a liability of the estate.
Your Honor, when you're saying from the credit cards, that's just a source. Am I correct? It's not a community division.
That's the source. No, it's not. I'm not dividing up the estate. I mean, I don't know enough about the estate yet to know how I would divide the estate up, or expert fees or attorney's fees and all those things that go into a property division. This is and payment of temporary spousal support. Those are things that I factor into final property division. But the $12,500, I see that there's a source to pay that expert through that Bank of America credit card. And right now, that appears to me to be the only liquid source of funds that I have available to get the expert paid. And so that's how I'm inclined to pay the expert. Now, if Mr. Manui comes across other avenues to pay it where he's not going to have to pay an interest fee on those funds, well, he obviously can do that. But he's ordered to pay $12,500 to the expert by April the 30th. And he's authorized to do that through that Bank of America credit card if that's the source that he needs to use to get those funds paid.
Your Honor,
can the request for temporary? Yes.
I'm sorry, I was just going to ask.
Yes, Mr. Tracker.
Upon the sale of those properties, can the first 12.5 or whatever is the debt at that point, so we don't continue to incur or accrue interest charges, can we use that first 12.5 to pay off that credit card and then do the division?
Your Honor, I would think.
Well, I'm going to say.
I'm sorry. I won't say.
I'm not going to make that part of my ruling today, Mr. Tracton, but I can tell you that that is something that I would hope the parties can agree to. If we've got and I don't know, they may have some kind of 0% interest kind of thing he's got with that Bank of America, some kind of offer like that. And if he does, then there wouldn't be any incentive to pay it off early. But if he's paying, 20%, 25% interest on $12,500, like some of these credit cards charge, then absolutely I'd want to get that paid and cut that expense to the estate. And that's something I hope the lawyers can agree to, but I'm not making that part of my ruling. If I need to weigh in on that later, then I would do that, but that's my opinion on it. All right, as far as the temporary spousal support, I don't see any source to pay those funds. And I just don't see it. So the request for temporary spousal support, additional extension of the temporary spousal support is denied at this time. Unfortunately, these parties may be living on credit for a period of time until we can get one of these properties sold. I'm not going to sell jewelry and I'm not going to sell a vehicle at this time. It sounds to me like there's a lot of sentimental value in the jewelry. There's a lot of sentimental value in the cars. I didn't order the sale of the marital home last time because there's a lot of sentimental value in the marital home. But I'm running out of options as a judge. And I have a credit card that I can tap today. But if y'all come back in here in 3 months and we need to get more attorneys paid and we need to get experts paid, and these properties in Sun Creek have not been sold, then my next choice is going to be vehicles, because that's going to be the stuff that moves quickest. And I don't want to do that, Mr. Manui. I've heard your testimony that you don't want to sell those. And Ms. Manui, I'm sure there's some assets that you don't want to sell. And this court's going to try to divide your estate in a way that allows y'all to keep those assets that have sentimental value to you. But at some point, a judge runs out of options because there's not any liquidity in this estate, and I'm going to have to start selling things that people don't want me to sell. But I'm not doing this. I'm not going to do that at this time, because I think that that hopefully there's sufficient income, potential income, to be made from this business to continue to pay the expenses as they're due. But I don't have any confidence in that based on the evidence that was presented to me today. So the request for temporary spousal support is denied. I can continue to use that American Express card, and I understand.
Is going default. I mean, we don't have the money to pay it. So if it gets charged, it's going to get charged. But I'm just letting everybody know there's not going to be money to pay it. We're going to have to live on it, and it is what it is. So.
Right. Well, y'all are going to be. It sounds like be living on debt or living on borrowed money until such time as one of these properties sells. If a property doesn't sell quickly, then, like I said, I will start selling off vehicles and jewelry. But I'm not going to do that today.
Well, Your Honor, there's only one person.
All right, that completes this.
That's
yes, sir, Mr. Broussard.
Saying, Your Honor, there's only one person that's getting a check here, and that's Mr. Minot. You know, he doesn't even have a rent expense. He's got over $5,000 a month coming in, Judge. But
Your Honor,
No, I'm paying the public.
he pays.
He's paying. I understand he's paying everything right now, pretty much. So I know where the parties sit. If there was more income, I would be giving wife probably another couple of months, maybe 3 at the most. But the fact is, I set this temporary support to end at a time I thought this case would be completed. And I understand it's not completed. And part of that is because the person that's responsible for getting documents to have the expert review the value of the entity is potentially throwing up a roadblock to doing that. And I'm giving some advice today that may cure that issue. If it doesn't cure that issue, then probably when y'all come back, I will be inclined to sell things that have a lot of sentimental value to that person, so that I can get these things paid. But that's based on the evidence I heard. I don't see where I have any additional source of income to get her any temporary spousal support at this time. If she needs to get something, even if it's $2,000 a month, she needs to get something as quickly as she can. And I know she's working at that. I heard that testimony. All right, entry of this order will be for April the 30th at 9 a.m. Mr. Broussard, you'll draft the order. And why don't we go ahead and do this? Let's put the sales proceeds of the Sun Creek Ranch. You can put this in the order as well. Those will go in Mr. Broussard's IOLTA account. There's not to be any withdrawal from those funds unless it's the joint agreement of both Mr. and Mrs. Manui or it's a court order. But obviously, if this case is not settled by the time those things sell, I would be looking at getting attorneys paid and getting both sides any relief they need to get their needs met. All right, that completes the ruling in this court. I'm going off the record. Anything further before I go off the record from either lawyer?
No, not for me, Your Honor.
And
With the house.
Your Honor, in your ruling, are you going to put that the parties are going to work on the house and its sales and
Well, the agreement was that y'all would sell the marital home, and but there's a lot of unknowns, and the realtor. Y'all can put that in there. But as far as what needs to be done beforehand, obviously Ms. Manui has no source to fund, so Mr. Manui is going to be paying the costs associated with getting the house ready to be put on the market. And but I'm going to let y'all try to work through those issues. If y'all can't, then you said about a 30-minute hearing, and I'll make those decisions. But I think that the parties and the lawyers hopefully can work out those issues. If not, y'all can get a hearing date on the first. Do what?
When we started at the beginning of our hearing earlier, we had talked about the idea of getting a hearing date a few weeks out because we don't want to just keep forcing ourselves further down the line in timelines. So we'd like to be able to get a hearing date, and we'd rather
Yes.
give up the hearing date because we have an agreement than try to get a hearing date and be losing weeks.
Well, the Sun Creek properties, hopefully, if they are listed immediately and we get some movement on those quickly, that will take up the urgency of getting the marital home on the market right away. But I do think it's the prime time to get the house on the market. So why don't we can set something like y'all can get a date the second week of May, the week of May the 10th. So y'all can just let the coordinator know that I said y'all can have a hearing date one day, May the 10th. I am going to put y'all on the clock for that. So each side's going to get about 20 minutes to present, your arguments on what should happen with the house. And we're going to have that entire hearing within 40 minutes because my hope is y'all can narrow a lot of those issues down.
Thank you, Your Honor.
All right, thank you. That completes the ruling of this court. We're off the record. Thank you,
Thank you.
gentlemen. Both lawyers did a very good job. Thank you.